ನಾವು ಡಾಕ್ಯುಮೆಂಟ್ ತಗೊಳಕಲ್ಲ ಕಾಪಿ
ಇದ್ರ ಹತ್ರ ನಾನು ಹೋಗಿ ಹೋಗ್ತಿದ್ದು ಇಷ್ಟ
ಲಿಸ್ಟ್ ಮಾಡಿಸಿ ಮಧ್ಯಾಹ್ನ ಅದು ಬಟ್ ಆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬಹಳ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ. ಲಿಸ್ಟ್ ನೋಡಿದ್ರೆ ನೀವು ಅದು ಯಾರು ಸರ್ವಿಸ್ ಆಗ್ಬೇಕು ಅಂತ ಹೇಳ್ಬೇಕು ನೀವು ನೋಡಿ ಮಧ್ಯಾಹ್ನ ಹೇಳಿ. ಏನಕ್ಕೆ your response 28 the request of the Lower Council for responding. A short accommodation is granted on the ground that the arguing council is traveling. We looked on 10/10.
Flat
23 will come to.
flat serial number 32, madam.
32. Yes.
Other side advocate has requested me to furnish the petition and the document, madam. I'll furnish today only, madam. They've asked me to.
You're applying for whom?
I'm applying for petitioner, my lord. The respondent council has asked me to furnish the copy of the memorandum of
copy
petition.
furnish ಮಾಡಿಲ್ವಾ 6 ವರ್ಷ ಆದ್ರೂ?
No, my lord. Last time on 9th he has asked me. I will miss again.
What is this, Mr. Council? 6 years you take to furnish copies.
My lord, we have furnished, my lord. They are not our copy sikkilla anta they are requested.
32. Lower Council for response submitted. You have not received copies. of the petitioner and annexure, the counsel for the petitioner undertakes to furnish the same
Please,
by
ma'am.
end of day 19th September.
Please,
If the same is not furnished by that date, the petitioner will be liable to dismiss for non-prosecution.
please.
26/9.
Plus 39, my lords.
Just a minute. 38. Really? Counsel for the petitioner seeks for and is granted 2 weeks time to produce certain additional documents. Relist on 10/10, interim order earlier granted is extended to next year. Yes, madam?
My lords, 39, I appear for the respondents, my lords.
Yes.
Lords, I request for the matter to be accommodated.
You are
First
appearing
week
for whom, madam?
Respondent number 2, my lords.
Sharda Bai or Mr. Swaminathan?
Sharda Bai, my lords. Sharda.
We Sharda Bai has entered appearance for respondent number 2, registered as.
I've informed the other side, my lords, any date after the vacation, my lords.
39.
We've informed them, my lords.
IA 1 of 2022 and IA 2 of 2022 is allowed. Relist on 10/10/2022 for final hearing. Interim order earlier granted is extended to next year.
Sorry to make submission.
26 has not been followed.
Interim order may kindly be extended, madam.
Not eligible for mention.
Like serial number 32 interim order may kindly be
Make
extended.
your submission when it is called, please.
Please.
Yes,
Serial number 32 interim order may kindly be extended, madam. Sorry, madam.
30.
32, my lord. Interim order may kindly be extended, please. Grateful, madam.
List number 230, my lords. List number 2.
List number 3, Mr. Achappa.
Oh, I'm sorry, my lords. List number 230 is what I wanted to mention.
230 listed. Take it up at 230.
230 can be mentioned, my lords?
You mentioned at 230, Mr. Achappa.
Please. Obliged.
I
Sir. Sorry.
into this document.
Please.
Mr. Suresha? IA1. ಏನಾಗಿದೆ Mr. Shetty? This matter? State civil advisory. None appears for the petition. Office of Fiction based on IA1 of 2022 has not been complied with. Finally, 10 days time is granted. If a week time is granted, if the office of Fiction not complied with by 23rd, the IA number 1 of 2022 will be liable to be dismissed. Readers on 26/9. Sole petitioner, sole petitioner. Memo along with death certificate of the sole petitioner has been filed in both the matters. The same is taken on record. The petition is dismissed as abated. Petitions are dismissed as abated.
I'm appearing respond number 2, my. The matter is likely to be settled, my. Kindly have it 1 week time may be granted. Settle. Negotiation was going on.
But we won't allow 2 councils to appear in the matter. You are going to appear for whom? One guy appear. One is abated, then one day council. She so and so submits that he has issued a no objection to Halakrama. As regards petition number 2 to 5, she so and so submits that he would be entering appearance for petition number 225 by filing Wakalatnama. Registry to Sri R. Chandrasekhar is discharged from the matter. Registry is directed to print the name of Sri so-and-so as that appearing for petition number 225. Put up agidya. Put up agidya. Mate. Chandrasekhar, the counsel for the petitioner submits that he has given no objection insofar as petition number 225. Sri R. Chandrasekhar has entered appearance. R. Chandrakumar has entered appearance for petition number 225. Sri Chandrasekhar K. is discharged from the matter. Registry is direct to delete his name as that appearing for petition number 225. Both the counsels submit that the matter is likely to be settled given yesterday. Given a week's time, released on 20th Nale. Tuesday.
28.
Report ಮಾಡ್ತೀರಾ?
28 man.
Agreement 28
ಮೇಲೆ 28
ಇಲ್ಲಿ 20 ಅಂತ ಇದ್ದಾರೆ
28 ಮೇಲೆ ಅದು ಅಗ್ರಿಮೆಂಟ್ ಆಗ್ಬೇಕು ಅವ್ರ ಮಧ್ಯದಲ್ಲಿ ಆಗಲ್ಲ.
Given a week's time, there is report settlement. Released on 28/9.
Much please. Much.
None appears for the petitioner. Office objections have not been complied with for 7 times. It appears that the petitioner is not interested in prosecuting the matter. The petition is dismissed for non-prosecution.
Okay. I'm for respondent, my lord.
Yes, madam.
I'm for respondents, my lord.
For respondent number 7, my lord.
Withdrawal was not on any condition, madam. You did not say that at that time. Your application may only not survive for consideration. So this is a withdrawal simpliciter. Who is the person who has to comply? No, that agreement, whatever you said, to be entered into. Which respondent?
My lord, respondent number 125, my lord.
New Year get
Nanu respondent number 125, my lord.
125. Counsel for the petitioner seeks for and is granted 2 weeks time.
Kindly, it may be listed on Tuesday, my lord. Connected matters are coming for final hearing, my lord. Before that,
that will go before the roster bench. This will come because of recall. That won't come up before this bench.
Yes, my lord.
Counsel for the petition seeks for 3 days time to comply with the office objection. Released on 21/9.
Obliged.
It was after purchase, it was renumbered at 39/2. Is what it is, like a CD. Para 1 and 39/2 is a new is one number at 39/2, so there can't be anything wrong. Please see the petition, madam. Para 1 page, Para 1 notice. In the petition, last line notice.
And the land retained by the member of the petition is given as survey number 2.
Okay, that is 39. When I counsel for the petitioner submit that there is a typographical error in para 2, line 6. In as much as survey number 39/2 ought to have been survey number 39/1. Accepting the said submission, the Registry is directed to carry out necessary correction and issue a certified copy. ಒಂದೇ ಜಾಗದಲ್ಲ I1 of 2022 stands allowed. Please inform order.
Number 7.
Mr. Bhatt. Mr. Bhatt, please unmute yourself. Mr. S.V. Bhatt. Unmute yourself. Also.
Look, serial number 8,
I
I appear for the state along with Mr. Murugesh Charati.
Yes.
That we have applied for recalling your lordship's order dated 27/6/2020. Kindly peruse that order.
27/6/2020.
No, not 2022.
2022.
2022, I'm sorry. That in the order dated 27/6/2022, kindly peruse paragraph 3. Shri Ashok Harnalli Learned Senior Counsel would submit that in view of the decision of the Honorable Apex Court dated 19/5/2020, in civil appeal numbers 2116 and 2128 of 2020 and other matters, it would be required for the state to make its position clear in pursuance of the decision of the Honorable Apex Court.
Yes.
Then, my lord, your lordship notices my learned friend's submission and then directs in paragraph 5 that an affidavit to be filed on or before 11/7/2022.
Yes.
But our submission is this. Your lordship has made this order in WP 27491 of 2018. But kindly take WP 27491 and 492.
Yes.
And please see the prayers at page 19. Lord, the petitioner is Muniamma. Page 19.
Page
19.
8, Mr. Vijay 19 is a different. 19 is
Prayers in the writ petition. Prayers.
19 is annexure D. Page 10 is the prayer.
Lord, I'm sorry, there seems to be, but I'm inviting your lordship's kind attention to the prayer.
To set aside the preliminary notification. To set aside the preliminary notification.
Yes, my lord.
Yes.
To set aside not only the preliminary notification, kindly come to AA, final notification.
Yes.
Now, and also over the page, issue a writ of mandamus directing the respondent's authorities to confirm the position of the petitioners, or if taken symbolic position, the same may be considered in terms of the representation dated so and so submitted by the petitioners. But the subject matter of this writ petition is land acquisition.
Yes.
Now, please see the order of the division bench of this honorable court and that of the Supreme Court in 2116. My learned friend, Mr. Charati, will pass on copies of that.
Yes. This is a peripheral ring road project. The Supreme Court has observed there is a confusion as regards whether the observation made by the apex court is only as regards the peripheral ring road.
Please,
Or so that is why the clarification was.
No, that clarification is not required. Kindly see the order of the division bench of this court, dated 15/10/2019.
The order passed on consent, Mr. Vijay.
No, it's not by consent. Your lordship is directed. It's not by consent.
Authority, there is no consent.
It was argued in the
Additional Chief Secretary is traveling, if you remember it right.
My respectful submission is this.
It was argued in the presence of the BDA council, and later on they have taken time 2 times, my lord, to file this affidavit.
No, we have not. But if I'm able to convince your lordship.
Yes, please, the division bench judgment.
Yes, no, my lord, please see the division bench order 15/10/2019.
Yes.
This is a petition filed by Nandi Infrastructure Corridor and Nandi Economic Corridor, and the respondents are Bangalore-Mysore Infrastructure Corridor. Then all this. Now, this writ petition was allowed by the division bench. Please go to page 62, the order.
Yes.
Writ petitions are allowed. Communication bearing number so and so, issued by first respondent to the petitioner, is hereby quashed. A writ of mandamus is issued directing the first respondent to issue commencement certificate as sought for with the petitioner in its application bearing number so and so expeditiously at any rate within. Now, Miller, from this order, there is an appeal that is 2116. This appeal is by the Bangalore-Mysore Infrastructure Corridor Area Planning Authority and another.
Order. Supreme Court.
That is part of the compilation which I have given. Compilation of the judgment. I have given it. That is the second judgment in that compilation. 2020 SCC only.
In this judgment,
just a moment, Mr. Shankar, we are taking out the debt.
Filed along with a memo on 27/6/2022.
Let me revision the 2020 SEC online 463.
Yes.
yes, my lord, but I have here, I am sorry, I don't have the report, but I have a certified copy of the order.
Yes, para.
But in this paragraph 63, but I don't know whether the paragraph.
It starts with it's not necessary for us to
Please. It is not necessary for us to dilate on other aspects regarding the efficacy of the framework agreement and the project technical report or other agreements executed between the parties, having held that it is for the state to consider the proposal for allowing the project proponents to deviate from the stipulations and specifications of the framework agreement and the PTR, and until the decision is taken by the state or its instrumentalities, including the empowered committee constituted in terms of the framework agreement, the planning authority cannot process the proposal application directly submitted by. Then will kindly go to this is I'm demonstrating that the subject matter is a framework agreement. Now please go to paragraph 66.
Yes.
As a result, we have no hesitation in taking the view that the direction issued by the High Court in the impugned judgment, in any case, cannot be countenanced in law. But this question, if we may say so, has become academic for the view that we have already taken that the project proponents could not have directly approached the planning authority for approval of the modified proposal, which was replete with deviations from the stipulations and specifications in the framework agreement read with the PTR. Then, my lord, this is so because the right in favor of the project proponents to carry on the development work on the lands referred to in the framework agreement and the PTR would be ensured only in conformity with the stipulations and specifications in the stated documents. It is not open to the project proponents to develop the land in any other manner unless permitted by the state. Then, my lord, one more observation, paragraph 69.
Hmm.
Accordingly, the impugned judgment and order is quashed, that of the division bench, and set aside, and the stated writ petitions filed by the project proponents stand dismissed, with liberty to the project proponents as aforesaid. The appeals are allowed in the above terms. There is absolutely no connection between Munirma's petition, which is for quashing the land acquisition notifications, and the judgment in 2116 and 2128, where the subject matter is a framework agreement between the parties. Please see it has absolutely no connection. But for reasons best known to themselves, they're requesting your lordship to direct the state government to file an affidavit.
What is the state government stand, Mr. Vijayashankar?
Well, the state government stand is that I am not required to file this affidavit because the two cases
What
are
is the state government stand on para 63?
Well, at para 63, please see para 63.
Yes.
Paragraph 63, that question doesn't arise again because the subject matter here is framework agreement. We'll
do one thing, we'll allow the writ petition, Mr. Vijayashankar. We'll allow the writ petition, quash the acquisition notification, because that is what it had come to when this submission was made.
Yes.
The only reason why the order was not passed was this submission, because your acquisition notification is of the year 2002-3.
Well, now you
2003.
No. I am referring to. But is your lordship referring to Munirma's writ petition?
No, we are speaking of the present writ petition. Yeah, Munirma's writ petition.
That's right, my lord.
491.
In Munirma's writ petition, again, my lord, at the risk of repetition, the subject matter is land acquisition.
Yes. Land acquisition for whom?
Beg your lordship pardon?
Land acquisition for whom?
Well, land acquisition, kindly see the notification. They produce that.
So is it your submission that is not for Nandi infrastructure?
Yes, my lord, it is not for Nandi infrastructure at all. It's some conversion. Kindly see the.
So we'll record your submission that is not for Nandi infrastructure and we'll delete them from the area of party.
Well, my lord, please see the.
So that is the decision that you have on para 63. You filed your petition. Why should you come in the way of a landowner? Now the submission is.
It is acquired for our purpose.
That
is the problem, Mr. Vijayashankar.
If that writ petition is allowed, it's really not going to be detrimental to our interests. All I am saying is the issue here and the issue in 2116 are absolutely different. Framework agreement on one hand,
the
land acquisition
of Mr. RVS Naik last time, you were not there at that time, Mr. Charity was here. This went on for quite some time.
Maybe
it is not a minute short.
I was not present.
We remember this because it went on for some time. Mr. Ashok Karnataka did make the submission. In another matter, he made a submission. The Supreme Court as regards a BDA matter, where the Supreme Court has said as regards peripheral ring road. And this matter, the submission was that the acquisition being for the benefit of Nandi infrastructure, unless you take a stand, the state takes a stand, whether it is for Nandi infrastructure or not, whether you are going to allow the project proponents to deviate from the stipulations or not, the consideration of this matter cannot be done. This is the submission which was made. That is why we asked for an affidavit to be filed. Affidavit this way or that way, what is wrong in filing?
No, my submission is this, my lord. The chief secretary cannot be directed to file an affidavit with great respect.
So who would file the affidavit?
But whoever else, my submission is
because the submission made, if we remember right,
on behalf of the state.
There are 3 departments involved. Therefore, chief secretary is what was suggested.
No, the state, my submission to lordship is the state cannot be directed to file an affidavit in a matter which is absolutely alien. Land acquisition on the one hand and framework.
Let the matter proceed because state is refusing to file an affidavit, even though they were called upon to make the stand clear. then it may be recorded that they're refusing to file an affidavit
No,
to
my lord,
make the stand clear. And
I'm-
another thing is this nice project, my lord, I am also requesting a further order.
Yes. Yes, Mr. Vijay.
So that's my submission, my lord, kindly consider that.
Yes, Mr. Arnoldi.
My lord, I have a further submission to make. Now this nice project, my lord, so far as the road portion, last time I said I have no objection. In respect of the remaining area, which is part of the intersection, why do they want to use that area, my lord, was my submission last occasion. Because this intersection, they are not permitted to put up any construction. In that background, I made the submission. Now I am making a further submission in respect of this nice project. Now this project itself appears to have been abandoned. Now no acquisition has taken place beyond the Bangalore.
We will come
They
to
are
this.
not making any effort. Let them make the stand clear, Lord. Are they going to do construct this road or not? Why take away everybody farmers' land only to collect
State
only
is
around?
not constructing, Mr. Arnoldi. State cannot file affidavit that they will construct.
No, but what is the
That
no?
cannot be
Nearly
done.
20 years are over, my lord. Now what is happening to this project? I have also made an application on additional ground that this project appears to have been abandoned. Now they are constructing a new project.
But
Now that road is already ready.
Again, my
No
lord,
acquisition has taken place in
that
Ramnagara,
is
Mandya
not
and
the,
other
that
places.
is
No
not the subject
construction.
matter of Muniamma's petition.
No, that is my case that you are acquiring for a project which is never take place.
No,
And
acquisition.
it is only to give them land in and around Bangalore.
My lord, they are asking,
That is a clear Malamede acquisition.
seeking for, if your lordship sees the prayer again, they want the acquisition notification to be quashed.
The ground should also be important, Mr. Vijay Shankar, on what grounds? Now, be that as it may, we can't now get into the merits of these contentions which are being, because it's only a recall application.
Yes, that is
The order which was passed was by consent. And then thereafter time was taken also because the additional chief secretary was to brief, was traveling on some
Then your lordships,
conference.
then your lordships may allow this Muniamma's petition.
No, we won't, because we are out of the roster. We are only considering the application.
whether it is recalled or
That's all. That the roster bench will decide. On that day, it was supposed to be allowed. When this came up is what we informed. An application.
For recalling.
In IA number 3 of 2022 has been filed for recalling the order dated 27/6/2022. IA 3, sir.
IA 3.
By way of the order dated 27, by way of the said order, on the basis of the submission made by all the councils, that is, Sri Ashok Karnataka 11 Senior Council, Sri RBS Naik 11 Senior Council, and Sri Murugesh B. Charity 11 Special Council appearing for the state. An affidavit of the Chief Secretary Government of Karnataka explaining the stand of the state as regards the observation and direction of the Honorable Apex Court. In Civil Appeal number 2116-2128 of 2020, dated 19/5/2020, more particularly para 63, was directed to be filed. It is the said order which is thought to be recalled by IA 3 of 2022. Sri Vijay Shankar and the Senior Council will submit that the subject matter of CA number 2116-2128 of 2020 and the present petition are different. And as such, there would not be a requirement for the state stroke the Chief Secretary, Government of Karnataka, to file an affidavit. Sri Ashok Karnataka and Senior Council would however submit that the basis of the challenge of the acquisition is as regards the acquisition having been made on behalf of the Nandi infrastructure, Nandi, what are those two names?
Nandi Economic Corridor
Nandi
Enterprise.
Infrastructure Corridor Enterprise Limited, which has subsequently been assigned to Nandi Economic Corridor Enterprises Limited. And as such, when the said project has not gone through, the ground for challenge for the acquisition is that the road has not been laid, and as such, the observation made by the Honorable Apex Court in Para 63.
Road is formed, but the adjacent intersection area they cannot use.
Though road has been formed, the adjoining intersection area cannot be used or made available, since what has been upheld is only the road project and not the adjoining infrastructure project. Correct. Both the submissions which have been made by the learned senior counsel are touching upon the merits of the matter. What this court is only concerned is as regards the recalling of the order. And as such, this court restrains itself from expressing any opinion on the said submission. The order dated 27/6/2022 has been passed with the consent of all the parties, all the councils, and subsequently on 13/7/2022, an adjournment being sought for on account of the fact that the additional chief secretary, who was to brief the chief secretary, was traveling for a point meet, and as such the affidavit could not be filed, would indicate the said consent. It is now not open. That is why the chief secretary has got 3 departments in the okay, we understand your trouble. The order having been passed in the presence of all the councils, and subsequently an adjournment being sought for on 16/8/2022. I have the considered opinion that the said order does not require to be recalled, and the affidavit as directed will have to be filed. However, since the S. Vijay Shankar and the senior counsel will submit that the chief secretary may not be in a position to file, it is left to the concerned principal secretary to file necessary affidavit.
Order is modified to that.
The order is modified to that extent.
This matter will go before the regular bench or before this bench?
Regular bench, Mr. Place the matter before the regular officer. Your consent again. All the consent is your consent and the interpretation. Our consent is so we understand your problem, that is why we have modified it. Your time and any other principal secretary could file, Mr. Vijay Shankar.
To be filed within what time, Lord? That's the
time to do this. So don't fix a time again, my lord. Again, they will come and say,
no, that's contempt. Decide that, Mr. Arnandi, we should not impinge on that. IA 3 of 2022 is partly allowed.
Please.
Paso. Chandrasekhar? Despite the order date 10/8/2022, none appears for the petition.
serial number 10, Lord, your Lordship may take it up next week.
Then you are appearing, Mr. Arnandi?
He requested me to appear. I still don't know. I don't have the papers. Your Lordship may have it next week.
Because it's posted for dismissal. I think any matra bandidara.
Oh, I don't know. If it is posted,
the senior counsel seeks for and is granted for next time. Released on 10/10.
Sorry.
Maintainable settlement. Maintainable, just because there's a divorce which has happened, DV is a offense which has been committed prior, unless you arrive at a settlement. That's not sufficient. That won't result in washing of the proceeding. If arrived at a settlement, then we can. Where counsel for the petitioner seeks for and is granted a week's time to produce the decree of divorce granted by the family court. We just on 26/9. 9. Shuramu. Petitioner. ನಿಮ್ಮ ಪೇಪರ್ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗಿದೆ ಹಳೆ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಹಳೆ ತೆಗೀರಿ. Counsel for respond number 2 seeks for and is granted 2 weeks time. File misplace ಆಗಿದೆ ಹುಡುಕದು ಸುಮ್ಮನೆ ಸಿಗತ್ತಾ ಅಂದ್ರೆ ಸಿಕ್ಕಿದೆ ಅಂತ. Seeks for and is granted a week time. We list on 26/9. Interim order earlier granted is extended next week. The Manu Kulkarni learned counsel submit that he has filed no objection or Galatnama. Put up idea. Registry is directed to put up the same, and if the Vakalatnama is filed, to delete the name of Shri Punitya and substitute it with Shri Manu Kulkarni's name. Next, Chandrasekhar. None appears for the respondent. If none were to appear for the respondent on next date of hearing, matter will be taken up for consideration in the writing. We will on 12/10. 14. 2018 ಇಂದ ಇನ್ನು ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ, ಇನ್ನೇನು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ. 4 years in the event when address arguments for admission. Where counsel for the petitioner submits that shifting his office is unable to get the file to get released on 12/10. It is made clear if arguments were not advanced on that date, the petition will be liable to dismiss for non-prosecution. Case number 19 number, but that's simple.
Please, Malad.
Ashwaya.
Malad, I represent the respondent, Malad. Kindly accommodate week time, Malad. Malad, the application which has been filed, but they are supposed to file objection.
I 2 and 3 new file madidira.
The respondent has been filed, Malad. Therefore,
Malad,
Malad,
respondent.
true, Malad. Therefore, Malad, kindly the file has been misplaced, Malad. Therefore, kindly accommodate.
Misplaced agide avatu.
The IA papers are not available.
Objections active. Request is learned counsel to respond number 2. ನೀವು ಕೂತ್ಕೊಂಡು you should use your good option. ನಿಮ್ಮ ಮಾತು ಕೇಳಲಿಲ್ಲ ಅಂದ್ರೆ ಅವರು
Unfortunately, Malad, the respondent is also an advocate. This was our problem, Malad.
And that is what Ms. Sadashipa is saying, both are advocates.
True.
Mediation ಏನಾಯ್ತು?
That's also fair, Malad.
Can we refer it to mediation? There, Mr. Sushila here, we can refer it to. The advocates and the senior or ibrene agadala. You're okay, madam? We can appoint you. Both of them are advocates.
No, my lord, this petitioner, yes, my lord, this is also an advocate.
So ಅದಕ್ಕೆ senior counsel ಹೇಳಿದ್ರೆ ಸ್ವಲ್ಪ ಕೇಳಬಹುದು ಅಂತ.
ಆಗ್ಬೋದು sir, ನನಗೇನಿಲ್ಲ. I have no objection, my lord.
15, both the councils submit that the matter could be referred for mediation. Ms. Sushila, learned senior counsel and senior mediator, is appointed as a mediator to mediate the dispute between the parties under the aegis of the Bangalore Mediation Center. The parties, the order being passed in the presence of both the councils. When shall we post it, madam? Next Saturday.
Any last week?
17th may be ನಾಳೆ ಕಷ್ಟ ಆಗುತ್ತೆ. 24th ಇಲ್ಲ. ಎಷ್ಟೊತ್ತಿಗೆ? On 24th.
3 PM would be
11 AM. ನೀವೇನು ಹೋಗೋದು ಬೇಕಾಗಿಲ್ಲ ಅನ್ಸುತ್ತೆ. ಒಂದಿನ ರಿಪೋರ್ಟ್ ಅಟೆಂಡ್ ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಪರವಾಗಿಲ್ಲ. 24th at 11 AM. Released on 1910. ಅಷ್ಟೊಳಗೆ ಕೊಡೋಣ, ಇನ್ನ ಜಾಸ್ತಿ ಕೊಡೋಣ ಸರ್. Holidays for it. Released on 21/11. Entry order earlier granted is extended to next year. Enquiry of fabricated documents ಎಲ್ಲ ಏನೇನು ಹಾಕಿದ್ರು ಸ್ವಲ್ಪ ಅಡ್ವೈಸ್ ಮಾಡಿಬಿಟ್ಟು ಕಳಿಸ್ತೀನಿ. The advocate is the worst client for himself.
grateful.
Ready, Mr. Shetty? Ready, Mr. Ambati? Who registered the complaint? Police. So not authorized.
Thereafter, again, PC has been filed with the same respondent body because the damage for having. And then memo. Same time number 18.
Very east memo appear agala idella copies ಕೊಡಬೇಕು. Just for Allah. ಒಂದೇ ಸತಿ. And counsel for the petition submit that. Produce ಮಾಡಿದ್ರೆ ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಆಗುತ್ತೆ. ಯಾವ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀವಿ ಅರ್ಧಂಬರ್ಧ ಮಾಡಿದ್ರೆ ಕಷ್ಟ. ಇವತ್ತೇ ಮಾಡಿದ್ರೆ ಇವತ್ತೇ ಈ ಸೂಚನೆ. Produce those. Next week produce ಮಾಡ್ತೀರಾ? Counsel for the petition is granted a week's time to produce orders and certain other proceedings which are bearing on this matter. Released on 26/9. Registry is directed to delete the name of T.S. Rachaya that appearing for the respondent and print the name of the learned SCGP. The Abhinaya sale and council seeks for seeks for a week's time since the arguing council was traveling. Released on 23rd.
My lord, I appear for respondent number 2 in this matter. Yes. A short adjournment as the.
I appear for the petitioner counsel.
My lord, the counsel is suffering from viral. I seek a short adjournment.
Posted the last chance for today.
Kindly have it for Wednesday, my lord.
Then you will have to produce a medical certificate.
Yes, my lord.
When an order like this has been passed and you come and make this vague submission.
with due apologies to the senior Mr. Ashok Haranalli as well. This has come up, all of a sudden, so we didn't.
Now, 18th, new appear ಆಗ್ತಾ ಇದ್ದೀರಾ?
Respondent, but senior appear ಆಗ್ತಿದ್ದಾರೆ ಡೆಲ್ಲಿಯಿಂದ. Senior son was appearing. ಇವಾಗ submission ಮಾಡಿದ್ದು senior ಅವ್ರ ಮಗ ಇವರು.
This matter has been listed today for appearance.
Yes, your lordship.
Submission is made that this date.
Due apologies. We got to know this morning that he's, viral fever ittu. He lapse agide anta. He left the office anta helidru. So we are making one last on a Wednesday. If he is not able to appear, we will finish the arguments. Now is submission.
Yavattu, madam?
Wednesday, please, your lordship.
Wednesday recovery agatta?
Your lordship, or Barley Landra, we will submission. May nave martivi submissions because papers ella Delhi le ide. So we'll get it here. Nave appear aagtivi. One last chance.
It is made clear that no further adjournment will be granted. Interim order earlier granted is extended to next date of hearing.
Grateful.
Counsel for the petitioner submit that the shifting is office and the file was not traceable. The 6th point is granted a each time, released from 28/9. None appeals. Released on 28/9 with manual to appear. Petition will be liable to dismiss for non-prosecution. Ready? Government counsel for respondent is directed to produce necessary material to show that there are ingredients in respect of permissible in section 323. The direction issue on 14/10/2019.
I will produce on 4 days. No,
3 years you have taken, Mr. Jairam, for producing this document.
Only next week without pay liable.
ASLSA doesn't have money. Learned counsel for the respondent once again seeks for adjournment to comply with the order dated 14/10/2019. The said order not having been complied with for last 3 years.
3 days.
Would not require indulgence to be extended. However, in the interest of justice, as requested by Shubhir Jairaj, 3 days time is granted, subject to payment of cost of ₹5,000 to the advocate's library fund, which shall be paid on or before 20th, released on 21st. 3 ವರ್ಷ. 3,000. Contractor ಅಂದ್ರೆ 30,000.
No, I am still there are proceeding arbitration. I have arbitration proceeding.
3,000. 3 years ಇಂದ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ what? Concede ಅಲ್ಲ.
But I will know these documents.
No favor like that. ಮಾಡಿ. Interim order earlier granted is extended. Answer? ಏನಾಯ್ತಲ್ಲ ಏನಾಗಿದೆ mediation report? $498, Shetty? None appears. Released on 28/9 with manual to apply the petition of liability to non-prosecution.
My lord, I am appearing for respondent number 2, my lord.
Then what is the report? Not settled. Who is appearing for respond number 2 now?
Madam, I am appearing for respond number 2.
Pradeep
Madam. Please, madam.
Shri Pradeep CS has entered appearance for respond number 2, delete N. Devraj. Allowed counsel for the petitioner seeks for 2 days time to make a submission released on 20 on 19.
Madam, 22, madam.
21st.
Please.
No further adjournment would be granted. If arguments were not advanced in that way, the matter would be dismissed for non-participation.
Much.
Number 24, Mohan Kumar.
24. None appears. If none were to appear on the next date of hearing, the petition will rise with respect to non-participation released on 28/9.
25. Mohan
Inform ಮಾಡಬೇಕಾಗಿತ್ತು. Senior counsel is here. Adjournment ತಗೊಳ್ಬೇಕಂದ್ರೆ you should inform the other counsel that I am going to take adjournment. Not ಅಲ್ಲಿ ಇಲ್ಲಲ್ಲ, ಇಲ್ಲಿ ನಡೀತಾ ಇರತ್ತೆ, ಇಲ್ಲೇ ಇರ್ತೀವಿ, ಅಲ್ಲಿ ಹೇಳ್ಬೇಕು. 25, the counsel for respond number 2 submits that the arguing counsel is traveling and released on 21st September. 20th now criminal matters thrown on 20th labor. 22nd or 23rd. 22nd labor. Tuesday, Thursday labor. Monday, Wednesday, Friday criminal. 26th. 22. Interim order earlier granted is extended. For whom? For whom have you filed your wakalat? Shivanna is who? Sole petitioner? There seems to be some 5 petitioners. You can't file wakalatnama for one counsel, Mr. We can't allow it. We'll reject all of them. We won't accept it.
What has happened is 20 years ago, when cognizance he has been appearing before the magistrate. In 2015, he makes a false submission before the magistrate that there is a stay from the government. For 4 years, he takes time. He has been accused of fabricating the order of this honorable court. He has been convicted by a division bench of this court, and plus the apex court has upheld the conviction and in the criminal contempt, and it is a reported judgment. In the meanwhile, the State Bar Council had departed permanently. The Bar Council of India said he is a young man, agreed with all the findings, and
This is in respect of accused number 1, petition number 1.
Rest of them are his family members. He sets them up. He says his mother-in-law is the stamp vendor. He has done all this. Now, in 2019, when he appeared, it is then he files this petition. 3 years ago.
What's your name, Mr. Counsel? Dawat Khan, you are aware what happened last time? Have you seen the order which has been passed last time? Have you seen the order which has been passed? So you accepted a brief without knowing what the matter is. We are not concerned what time you came. Have you seen the orders which have been passed? What is the order which has been passed last time? No, we are not allowing you to come on record. We are rejecting your wakalatnama. So you are free to go. Not about you. You don't need to appear in this matter at all. Sri H.G. Dawood Khan submit that he has filed wakalatnama for petition number 1. This court, while audited in 9/9/2022, has categorically observed that the different petitioners in the present matter cannot be represented by different lawyers, more so when there is no conflict of interest. It is clear that the reason why different lawyers are appearing for different petitioners is only to protract the proceedings and for nothing else, which is also borne out by the order sheet as recorded on 9/9/2022. This court had made it clear by said order that it was for the petitioners to engage one counsel or to file separate petitions. The same not having been done, I will consider opinion that a new counsel cannot now be allowed to appear for petition number 1. The wakalatnama petition number 1 only. Yes. The wakalatnama, will you appear for everybody, Mr. Dawood? On inquiry, Sri Dawood Khan submit that you would not be appearing for the other petitioners, but you would only appear for petition number 1. If that be so, in light of the observation made by this court on 9/9/2022, his wakalatnama cannot be accepted. We are rejecting your wakalatnama. We are. We are rejecting your wakalatnama, Mr. Dawood. Please understand, you have no right of audience. Is rejected. Now, in light of the earlier orders which have been passed, no time is required to be granted. However, as a last opportunity, 3 days time is granted, released on 21/9. If none were to, if the said order is not complied with by that day, the petition will be liable to be dismissed for non-prosecution. Please don't abuse the process of the court. Your client is a lawyer. If we say anything more, this is not the things that a lawyer can do. And not in this manner. And despite an order being passed, he has the audacity to try and change the counsel. Is this the way that can be done? You appear to be a senior person. You should advise them properly. We are not going to, we have rejected your wakalatnama. So we are not going to hear you unless you are going to appear for all of them. If you appear for all of them, we will hear you. Or you decide which petitioners have to be deleted from this. And make a joint petition, we will dismiss those. They can file separate proceedings, not like this. And each time one lawyer is coming for one of the parties and asking for time. And the other lawyers don't appear for the petitioners. We are telling you this so that now you know what is the situation. Each time one lawyer appears out of these 4. Only to take time. All submissions have been made. That is why we have observed there last time that there is no interim order and the trial court can proceed. You don't do these things. We should not, as a court, be telling you this. Not proper for us to do that. Not for you, but your client is now using you for a different nefarious purpose. So you also have to be careful as a council. You want to be used for that, then you also be part of it. You have to decide that. That's why we asked you, have you seen the order sheet? You said you have. Despite that, if you make the submission, that is not fair and proper. If you have not seen it, we will not have said it. After seeing it, if you make the submission, it is not proper. 21st. These kind of, let us refrain ourselves from saying anything. Yes, next.
That's one submission. The petitioner filed the already the case the petitioner after the charge sheet filed with the police. He filed another number 40530 of 2017. 530 of 2017.
Yes.
The present reason that the FIR positive for FIR, sent for positive for charge sheet.
ಅದೇನಾಗಿದೆ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ ಅದು
Notice ಆಗಿಲ್ಲ.
ಎರಡು ಲಿಸ್ಟ್ ಮಾಡೋಣ ಮಂಡೇ council for respondent number 2 submit that there is one other petition WP 40530 of 2017 which has been filed challenging the charge sheet while the present petition is filed challenging the FIR. Registry is directed to connect WP number 40530 of 2017 and they will release on 21st.
For instance, that is the prayer when the petition. Prayer number 13. Prayer aim to substitute any other prayer. First, someone distributed the first prayer. Second prayer. Consequently, first order 38 2018 part of the point action commission then see if you return mandamus or other order there in there restore the end user the prayer and already considered by the user bench of the Honorable Court. The prayer second and third is concerned.
Order.
I'm not receiving both prayers.
Why did you ask for it, Mr. K?
Previously,
Was this filed prior to that or post?
subsequently, this honorable court of this department will also be an order on 26th April 2019.
To application by 9/10/2018.
9/10?
2018.
46010 was filed on 9/10.
It is
15/11.
15/11. Subsequent to the application. And also, we have placed one more decision of the Honorable Court, page number. We also produced in page number 32.
No, was, all the rounds are because of your plan.
No, because later on it should not be said that.
You did not mention last time that these two prayers were not going to. Yes, you argued on those prayers.
But I am only on the single point that whether 7 committee.
That is what has been rejected by the decision bench.
No, Sorry, my lord, I will be now explaining the decision passed by Green Bench, of it is produced by way of a memo dated 26th August 2019, my lord. At page number 12, the internal page of that judgment is on at 10, my lord. At the repetition number 46010.
It's been allowed, writ petition has been allowed.
Please, my lord, it was allowed in that section. So here, paragraph number 14 may kindly be.
Prayer, no, Mr. Pallav, prayer B and C have already been allowed in WP number 460.
Yes, I'm not listening that. I'm only on prayer number 1, my lord.
That you did not say on the last page.
These are orders dated 17/20/18. It is stated that the petitioner had violated the decision of 7-member committee, which prohibited transporting of land outside the district. That's the only issue. For that, the Green Bench has very categorically said at page number 15, referring the decision of Honorable Supreme Court in case by Kanti state of Gujarat versus case by Kanti.
When you asked for that relief before the division bench, why did you ask the same relief here? You asked for the same relief in the division bench.
Yes, no,
Then why did you ask the same relief here?
because this is on a private complaint. I will
B and C.
B and C, for those days I have.
No, of course. Why did you ask it here when you asked it there?
Because I have filed a writ petition, 482 and 226 are filed.
You asked for the same relief and you don't bring it to the notice of this court also.
I have not argued on the last occasion. I was doing.
Did you say I'm deleting B and C?
I have on that day, I have not asked. I have
Don't
not
do
requested.
this.
And because I have now also touched upon that. Now also I am not addressing that both relief.
On account of suppression, we'll dismiss your petition. Have you stated in your petition that you had filed a writ petition?
Yes, my lord.
Where have you stated that? Where have you stated that you had filed 46010?
Just a moment, my lord. Here it is paragraph number 2, my. Most the petitioner being agreed with the petition dated 38/2018 passed by the commissioner as the chairman of Taluka and Municipal Committee, called as Taluka Committee, constituted right to 31R2 of Karnataka Management Change to and so, had initially filed a petition number 46010 of 2018 before the Green Bench of the Honorable Court.
You did not say that the same relief that you have sought for here had been sought for in those proceedings.
No, there are also the seizure of 10,430 metric ton ordinary sand. That is mentioned very clearly, my lord. And
you were able to obtain an interim order in this matter on that basis.
no, I have not so far. It's not to my best of my knowledge. No, it's not. Very straightforward, honest.
There is an interim order you got on 26/6/2016, Mr. Pallav. You are saying it is not.
Because now this is the petition or petition. I am only concerned with the complaint filed by the senior services.
Please see prayer B and C, whatever you asked for. Again, you are persisting with the same. Please see para B and C. Prayer B and C, please read.
Consequently, prayers of Secretary of Order dated 28/2018, passed by 661 Commissioner, so and so, ordering to seize or confiscate royalty suffered 10,430 from quality stand for which MDPs have been obtained for further processing and packaging. So this from 2024 by this petitioner as 7/22.4 produced an annexure F.
You came to this court on contending that the seizure has not happened. Mr. Kolle, you came to this court saying that the seizure has not happened, so therefore don't give effect. In the division bench, you went saying that release the sand, seized. Then there is a false statement and submission made.
No, absolutely, I am not making any false or incorrect submission. What I
Read that prayer and read the division bench prayer, both between.
division bench was finished, because based on the judgment, my learned friend has referred. Because even in that judgment also, in the agreement decision, page number 10, it is mentioned.
Please read prayer, page 3, where the prayers are extracted.
Page 3.
What is the prayer you have sought for?
Yes, my lord. Four points have been called down. For a writ subsidiary class with proceedings dated 38/2018 by the appellate commissioner directing the receipt of sand seized from petitioner, annexure A.
Now compare it to prayer B.
Consequentially, class was set aside. The order dated 38/2018 passed by 6th respondent appellate commissioner as counsel for info. Ordering to see or confiscating the royalties over 10,430 metric tons from ordinary sand for which NDQ have been obtained for further processing and packaging. I had to counsel factory owned by this petitioner as survey number 22.0 to reach Then the last C is the last prayer is issue writ of handover or another order to restore the end user registration certificate dated issued by third respondent director and also withdrawal public cancellation of order dated 14/18 passed by third respondent director. So that also now it is almost in the nature of influence. That has been either considered or it is director is now in the process of considering that person the order passed by release. I am now concerned only with relief sort of point number 8,
yes,
which says that directly grant of set aside the summons issued by the government additional and payment to the court in CC number 20. So upon a private complaint dated 20. So filed by 7th respondent geology at PCR number 24. Wide order dated 27/2018 produced at annexure A. Produced at annexure A in complaint filed by the geology. It is not challenge or influence. There is a statement of 25 of the petition I got. There is paragraph number 5 and the scientific perspective. Certainly, ಹೊರಗಿಂದಗೆ ಮರಳು ಸಾಗಾಟ ಮಾಡುತ್ತಿರುವುದು ಜಿಲ್ಲಾ 7 ಸದಸ್ಯರ ಸಮಿತಿಯ ಸರ್ವ ನಿರ್ಣಯದ ಉಲ್ಲಂಘನೆ ಆಗಿರುತ್ತದೆ. I am concerned with that. There is no such requirement or there is no enabling from law under creative rule. And that ಜಿಲ್ಲಾ 7 ಸದಸ್ಯರ ಸಮಿತಿ ಅದು after February 2016 ಅದು ಕೋರ್ಸ್ ಈಗ ಆ ಕಾರಣದ ಸಲುವಾಗಿ ನನ್ನ 10,000 ಸೀಸ್ ಮಾಡಿ ತಪ್ಪು ನನಗೆ ರಿಸ್ಪೆಕ್ಟ್ ನಾನು
petitioner is before this court seeking for the following reliefs. The petitioner, the above petition having been filed on 15/11/2018. The petitioner had earlier filed with petition number 46010 of 2018 on 9/10/2018, where he had sought for the following reliefs. Page 3 of it. The petitioner is seeking for exercise of discretionary powers vested with this court under section 482 of the CRPC to quash the proceedings which have been initiated in CC number 1440 of 2018. Though the petitioner in para 2 of the petitioner has mentioned about initially having filed WP number 46010 of 2018, a copy of the petition has not been enclosed. A perusal of the memo, perusal of the order passed in WP number 46010 of 2018 produced by the HCGP would indicate that the petitioner had approached I had filed a said petition earlier to filing of the present petition, seeking more or less the identical relief as sought for in pair B and C in the said proceedings, which has not been brought to a notice of this court. There being a suppression of facts, I am of the considered opinion that the discretionary powers are not required to be exercised in favor of the petitioner. More so when in the present petition, it is contended that the order dated 38/2018 has not been given effect to, while in WP number 46010 of 2018, it has been contended that the same was given effect to. On account of suppression of facts, I do not deem it fit to exercise the powers under section 482. The petition is dismissed as such. Let me check it. And used for the benefit. And used for the benefit.
Condition of public reception. Exemption to get RD.
You have used it, Mr.
Lordship can't see minority is only produced. No benefit minority has been derived.
No, not derived, Allah. You sought for, since all the above institutions now declared that they are linguistic. The provision of the RT Act exempting minority from RT may please be considered. Necessary direction may please be issued to the respective block education officer that our institutions will be extended benefit.
No benefit is not extended by them. I said what I am doing, but I am not included any benefit from that because I have the input.
Where did you get this data from? It has to be trial, investigation trial, the end trial.
And the earlier order passed is not followed.
Was used by the petitioner, so where it was used and for what purpose? You will argue that.
Thank you. That is categorical finding allowed recorded by the court allowed on a there.
Date?
My lords make 96 page 40, 52. Next one.
52.
Update page. Previous order. Build up the paragraph. Therefore, even if the court is attributed to the petitioner, the court has said, in the absence of any benefit being derived by the petitioner's institution or its judgment, it cannot be said that the criminal case could be made up. But you must be kindly see the order passed on the last occasion by my lord.
As to whether the alleged post certificate was used by the petitioner and if so, where it was used and for what purpose.
Yes. I have got no benefit is derived.
But you try to make use of it. I tried to commit a murder, Agila.
I have produced it for was the case. It is only when I production they verify it is stated that it is not been used by them. Otherwise, there was no occasion for them to register a case.
Right. So
I have produced it, thinking that it is genuine document.
So there has to be investigation made as to where it came from. Somebody has fabricated a government document, Mr. Chair. It's a serious offense.
They have already verified it, my lord. It's only then, my lord, they have not verified with the authorities, my lord. And
So
then
where did you get it from? Who gave it to you? Who made it? How investigation?
the person who has signed it only has delivered it to me. Subsequently, my lord, we have disowned its signature.
You are on the FIR, not you are on the charge sheet. Let the investigation happen.
Similar matter, my lord, have this honorable court, my lord, have already
You can
filed. Kindly, my lord, once again, my lord, not be reviewed.
This would be like saying that I tried to commit a murder did not happen, therefore don't punish. 307 ಆದ್ರೂ ಇದೆ. ಇದು ಏನಾಗಿದೆ ಅಂತ ನೋಡ್ಬೇಕಲ್ಲ. You have to have an inquiry. Investigation has to happen.
For the project, my lord, I will submit it to the court. We see, my lord,
After charge sheet, you must say.
liberty to come back, my lord, if need arises, my lord.
After charge sheet is filed, if need arises, not in between. After arguing for some time, then a counsel for the petitioner seeks permission to withdraw the above petition with liberty to challenge the charge sheet if any laid against the petitioner after investigation. Reserving such liberty, the petition is dismissed as withdrawn. The city, where is Namita Mahesh? ಬರ್ತಾ ಇದ್ದಾರಾ? Some order was to be passed on those securities. ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದಾರಾ? ನೋಟ್ ಏನೋ ಮಾಡ್ಕೊಂಡು ಬರ್ತೀನಿ. ಅವ್ರು ಬರೋದು ಏನು ಬೇಕಾಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ನೋಟ್ ತಂದ್ಕೊಡ್ಬೇಕು. ನೋಟ್ ಇದೆಯಾ?
ಆಂಧ್ರ ಪ್ರದೇಶ ಹೈಕೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಡ್ತೀನಿ, ಇನ್ನೊಂದು ನೋಟ್ ಏನೋ ಮಾಡ್ಕೊಂಡು ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿ
ಮಾಡಿಕೊಡ್ಲಿಲ್ಲ.
31 as a request of the deputy request on 23/9. Definitely file change.
On 30th of May,
ಈ ಕಡೆ ಬನ್ನಿ. ರೆಡಿ ರೆಡಿ ಇಲ್ಲೂ ಕೇಸ್ ಇತ್ತು. VC-ಯಲ್ಲಿ ಈಗ ನಾವು
reason why I noted, my lord, is that we have a case. In respect of the other actions, the case is already now at the stage of arguments. And it is posted to tomorrow. 2 dates, hearing dates are being given. Therefore, the matter is directly thought by the Supreme Court decision.
other accused ಅಂದ್ರೆ not in this matter.
In the complaint, my lord, not in this civil petition. In the complaint, they go to the learned judge. The 138 proceedings are initiated against the company and 3 persons, 2 of whom are directors on the date for issue and against the petitioner who are not a director. And I have come up in the revision and I have obtained the stay from the honorable court.
Post before a bench of which FTRJ is not a party. One name was striking, so there is not a complaint.
I request the Lord directly to put it up because we have moved the matter because of the fact.
Till the learned counsel for the petitioner submit that there is some urgency, reducing to take necessary permission and do the needful at the earliest.
Much
In this matter, I propose the second respondent, my lord. Matter may be possible, my lord. By 2:30, matter is settled between parties.
You are the report, Martira?
Please, my lord. Please, my lord.
Outline from Kerala. He is seeking for a passport.
You are ಬರ್ತಾ ಇದ್ದಾರಾ?
Please, my lord.
Pass.
Much please.
Mr. Girish. Where is Mr. Rajendra Reddy?
Information before.
We will put them on notice. Not do it without notice. Though counsel for the petitioner is present and ready to address his argument, none appears for the respondent. If none were to appear for the respondent and make the hearing, the matter will be taken up for consideration thereafter. Bail is on 26/9. Interim order earlier granted is extended to next day. Settlement ಆಗಿಲ್ವಾ? ಯಾಕೆ ಆಗಿಲ್ಲ? ಲಾಸ್ಟ್ ಟೈಮ್ ಅವರೇನು ಹಾಸ್ಪಿಟಲೈಸ್ ಆಗಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತೇವೆ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಏನಾಯ್ತು? Is there a settlement going to happen or are you going to address arguments? And then why are you appealing? You should know. When it is posted, first important. Even after ಏನ್ ಸಬ್ಮಿಷನ್ ಮಾಡೋದು ಕೇಳ್ಕೊಂಡ್ಬರ್ಬೋದು. ಏನಾಗ್ತಾ ಇದೆ? ಅಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ತಾ ಇದೆಯಾ? You want to address argument? What do you want? ಕರ್ಕೊಂಡು ಬನ್ನಿ ನಿಮ್ಮ ಟೀಮನ್ನು ಫಾಸ್ಟ್. ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಕೇಳೋಣ. ಅವ್ರು ಒಪ್ತಾ ಇಲ್ಲ ಅಂತ ಇದ್ದೀರಲ್ಲ, ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ you argue. Settlement ಆಗಿದ್ರೆ will give it back. ಓದಿದ್ರಾ?
Now I am pursuing this inmates of the foundation and even the founder of that organization, as ex-president, he has given so many statements have been given. Beaten and abused in many languages, and he cannot be confined more than 5 months. In 3 months, when it is permitted, according to the health and law. There, understanding it to be even voluntarily it should be done. They are not done it voluntarily. They have taken whether that is the instance of mother or whatever. But he cannot take he himself is submitting that I want to. They are not allowed. Human rights violation of human rights.
Nagaraju,
Yes,
which alcoholic?
he's an alcoholic, but he's going to
Which alcoholic will voluntarily say I'll go? The family has said that.
I admit your words.
Okay, criminal complaint ella file ಮಾಡಿ.
No, fine.
You are coming in the way of them. Whatever work they are doing, you will dissuade them.
Kind of oppression, he could not able to send the complaint. He was actually so much frustrated there. However, in the SPST, they cannot.
Obviously, he will be frustrated when he is undergoing treatment.
I mean, he is working as an accounts officer in Canara Bank. He is working. Even now he is working. How can he work with this kind of intermittent or whatever?
Produce certificate from his employer. Produce certificate from his employer that he is working properly. There is no complaint. Affidavit.
He has not been given issued any notice or whatever.
Affidavit acts your manager.
Even in the tax,
Even in the bed.
take a document from them.
Even in the bed. Or in the affidavit acts. Yes. Somebody is doing some good work.
Naturally.
And you want to come in the way of them doing good work. By filing false complaints.
He is an accounts officer. The accounting, doing accountants and all that, the confession and this thing. He should have some sense of understanding, sense of knowing and doing. See, doing something different is entirely different. This is actually working with calculations. I brought
You also verify
even
where is working, what is happening. Council for response is granted.
I
2 weeks time to file an affidavit of the employer of respondent number 2 that respondent number 2 is regularly working at the bank. Affidavit. Yeah. We can't rely anything but an affidavit. Of his employer, employer of respondent number 2, stating that the respondent number 2 is they've been diligently working with the bank without any complaints, and that is attendance is regular. Bail is done 12/10. Interim order earlier granted is extended.
Number 38, 39 of them, 14.
This is a dated matter. How the file ಮಾಡಿದ್ದಾರೆ ನಿನ್ನೆ ತಿಳಿಸಿ 17/8 ಇಂದ 5/9 ಇಂದ ಅರ್ಜೆಂಟ್ ಆಯ್ತು 2 days ಯಾಕೆ 5th or 6th ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಬೇಕಾಯ್ತು ನೀವು 2 days back and you want to take him by surprise. Did you inform him about the date? You mentioned because you had a problem on 19th. So we changed it to 16th and we directed you to inform Mr. Prasad. Did you inform? When did you inform? No, you did not inform, you only served it on. You want to take him by phone number, Ilva? Please don't do these things. You are Gajjanagar. You tried to save. and take him by surprise, we are going to adjourn it. You can't do this.
We have tried our best to keep the phone number, learn from my friend, I can report on that.
Fact is, you are not informed. On the last date of hearing, when the matter was, last date of hearing, the matter had been adjourned to 19/9. However, thereafter, the council for respond number 2 had pleaded personal inconvenience on 19/9, and that's why the matter was posted today. Shri B.S. Prasad, the counsel for the petitioner, submitted that he was not informed about the change of the date until 2 days ago when he served with the compilation of the petition. That is very unfair of the counsel for the respondent. Released on 12/10/2022. File your compilation.
Number 41. Vikram Banerjee.
Members of the share association. At the relevant point of time, you are the chairman of the village bank. Wanted to continue in the panchayat. The other member of panchayat events and of course the President. A complaint has been filed by the President, which can be taken at 78. This is that the police, this is a letter addressed by the President on 7/1/2016. Addressed to the police inspector, Karnataka police station. That you like to get the Vishaya. Anekal Taluk Satyagraha, Shantipura Gramada Sarkari Nirde, Quality Bitu Kulashita Mariva. Karnataka Dalita Selection Samatera Jilla 3/8/2020. Shantipura Gramastharu, Gram Panchayati Sabha. This is 15. Rajesh Nidisharu School Anekal Taluk Satyagraha, Shantipura Gram. Sarkari Kerege Shantipura resident of the Yes, Ramaswamy bin Kallapuriya, Chandramohan bin Munaraj, Shantipura resident of the nice Vinayaka Levana Vasati, Padavadegala, Manegala, Valacharangi Rasta, Kamagari, Padavani has Sampurna Kulishita Sarkari Kerege City, Alumna. Sutila Parisara Niru, Peta Vasana Provada, Sankraka Roga was Shantipura Residential Welfare Association, then Ramaswamy, Mohan Viruta, Chandra Mohan Viruta, Shistu Kamarita, Agu Keremo, Suspigate Tarado, that this is a complaint by the Tahsildar to the police station. And that came to the registered matter at page 79 and 38. In miscellaneous crime number 15 of 2016. And the authority says that it's a non-particular. Therefore, Madam, he issues a notice to the petition under section 91 of the CRP, page 82. Then do an application to the magistrate at 155, seeking for a permission. That is at Annex G, page 83. This is 12/1/2016. Then on 18/11/2016, he recorded the statement of the petitioner before a Lordship and filed one more complaint at page 88, saying that there is a violation of complaint number 71/2016, that is page 78. Therefore, the FIR has been registered. Virtually the same complaint. In fact, there is a drainage which has been constructed by the petitioner at the cost of the PWD, may take from page 120.
Constructed by the petitioner at the cost of PWD and the
No, in the panchayat chairman. He took the initiative. Drainage has been constructed, page 120.
Page 120?
Page photograph I just produced, page 120. This is a photograph. And we have also produced the cost where panchayat resolution at page 68. Shantipura Grama Panchayat. National Rural Development Guarantee.
Mr. Lakshman, page 120 nodre. Your constructions are next to the Rajkali. Where is the buffer zone?
No, construct. This is the Rajkali. This is the Rajkali. The drainage which we have constructed. This water goes to Rajkali. Now, ultimately, they give a complaint to me, sorry, to the police station on 7/1/2016. The permission is on 12/1/2016. Sorry, the application for permission. And on the very same complaint, they give, and that has been treated as an FIR. If the first complaint, if it is to be treated as a first information report, on 7/1/2016, 14/11/2016, that it can't be treated as a FIR. And what happened before the magistrate, it is still now pending.
Sorry, what was your submission? The first complaint of
7/1/2016 at 78. Then, the miscellaneous has been registered at page 79.
Yes.
Then, a police notice is given to me at page 81. Then, the very same complaint, an application, the police notice, everything has been forwarded to the magistrate seeking for a permission and work to be filed.
And charge sheet has been laid.
No, madam. Permission has not been still granted. Then one more complaint was given by the Tahsildar to the police station at page 88.
Yes.
Same substance. Then that has been registered as an FIR by the police. This page 88 cannot be treated as an FIR because this has to be treated as 168. If page 78 is treated as an FIR and registered as a misdemeanor, the very same complaint cannot be treated as an FIR at page 188. It has to be treated as one.
That is only NCR was given for that.
You are also correct.
So NCR as well in further details could the complaint is filed.
No. The magistrate has not granted permission till today. The application is lying with the magistrate.
Yavado?
Under 7/1/2016 annexed.
Okay, but 14/11 the different allegations are made.
No, same allegation. Same allegation. They also refer to 7/1/2016. Page 88, same.
ಇವಾಗ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿ ಚಾರ್ಜ್ ಶೀಟ್ has been laid.
ಅದು ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
ಅನೇಕ ಎಲ್ಲೆಲ್ಲಿದೆ.
ಚಾರ್ಜ್ ಶೀಟ್ has been filed. Number of people. They can't prosecute like this.
Being a member of the panchayat, if you are going to let the sewage into a lake, sewage into a lake is what the serious allegation.
Not by me, not by me. In fact, we have constructed a drainage.
You are occupying two different positions. One as a panchayat, the other one as the president of the association of this layout. The allegation is that layout has left the sewage into the lake.
That is an allegation in the annexure 78.
That allegation is
before the magistrate for seeking
permission.
That allegation has been investigated in wide complaint dated 14/11.
No. See, when the matter is pending before the magistrate at page 83, that is on 12/1/2016, if there is a permission granted, whether it is open for them to go ahead with the investigation.
No, Annexure L is in pursuance of 14/11 or 7/1.
Annexure J, I'm sorry, Annexure J.
14/11.
This is 14/11/2016.
Yes.
This is a letter of the Tahsildar. E and 7/1/2016 is one and the same. When the 7/1/2016 is pending before the magistrate for taking permission for investigation under 155 of the CRPC. If the second complaint cannot be treated as an FIR. But the other issue which I raised, is if it is covered by the Lake Conservation and Development Authority, neither the Tahsildar nor the police are going to speak and decide the authority under the Lake Development. So 277, one is 78, one is taxable, another one is not taxable. And 155 minutes unless there is a permission. Investigation.
277 is polling water of public spring or reservoir. Lake is a reservoir.
Yes. The allegation is that I am polluting the water in the lake.
Yes.
The stand of the petitioner is that under the.
So that is a defense.
That is a defense.
Defense, you are 482. Defense also told.
No, the allegation is I have constructed a drainage and leaving the water to the lake. That is it. Now, the document which we have produced before your lordship says that under the PWR, that is Shantipura.
If you use PWD funds, it doesn't, the illegal act doesn't become legal.
No. I have constructed a drainage.
Now, this drain that you have shown at page 120, does it go to the lake?
It won't go to the lake, but that is a
120 already.
But it goes to the Raj Kalve over there.
Raj Kalve lake is over there.
Raj Kalve goes for that. In fact, this layout where we are staying, in fact, I have stated in the petition. After our layout, there are other 3 layouts in the village. Then the lake comes. That is how it is an extreme case of invoking the criminal jurisdiction.
This 120, the photograph where you have constructed this drain, goes to a Rajakalve, admittedly. Rajakalve goes to a lake, admittedly.
No. Rajakalve doesn't go to the lake. It goes outside the village.
Rajakalve connects lakes.
That is a natural course of water flowing in the village. I am not responsible. It is only the authorities are responsible. Lake authorities have to rectify it. If there is a pollution in the lake, the authority under the lake, constituted under the Lakes Authority will take action.
That is a separate thing. 277 continues as it is.
No, so far as 277, 278 is concerned, if the special enactment is already taken into consideration, then the authority under the special enactment and along with the IPC, they can take action.
I didn't get it.
Yes, that is a.
By Lake, by the Tank Conservation Authorities Act. Does it say 277 and 278 is obsolete or removed?
But the short question, whether first the Tahsildar is entitled to give a complaint or not. And other member, who is a rivalry to me, takes in hand. That is how the Shara said, this complaint of 14/11/2016,
A panchayat member bring it from Tahsildar and give it to the person.
Other than you have a different arrangement. That is a question of fact. You have to prove it. We don't know whether a panchayat member gave it. But what we are concerned with is when there is a drain which has been built by you using PWD funds going to a Rajakalwe. Even a Rajakalwe is a reservoir or the water for the public purpose. It's not your private land. Private Rajakalwe is a public. So it is an offense under 277.
Who said, Malad, we have constructed a village drainage. That water goes to the Rajakalwe.
You could not have ever constructed like that. You could never have constructed something.
There is a
like that.
permission granted by the
And
authority.
that permission is also bad. That's also a crime. Whoever is granted, they can also be prosecuted.
But case, if that is the case, as a panchayat chairman, I am not the only one responsible. The entire panchayat is responsible. Case 68, Malad. Kindly take note. Case 68. Shantipura Gram
We
Panchayat.
will direct further investigation into who are all responsible.
Well, I should
That we will do. But we can't watch this.
I will leave it to your lordship, Malad. So far as
So according to who are all responsible, all panchayat members,
well, I will file an affidavit. Your lordship, I will come Monday.
everybody has to work with this whole model.
Serious.
ಯಾರು ಅವ್ರ ನೀವು ರಫ್ ಆಗಿ ಹೇಳಿ ಆಮೇಲೆ ಅವ್ರ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಯಾರ್ಯಾರು ಬರ್ತಾರೆ ನೋಡಿ.
No, I don't want to commit any mistake. Whether he has got anything in his mind not to utilize this opportunity to save somebody, which I don't know.
ಅವ್ರು ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ನಾವ್ ಹೇಳ್ತೀವಿ.
No, I will advise it properly. Actual facts, I will take this talk of it and I will file an affidavit. I have no objection. If there is a sanction by the statutory authority, if it is constructed, along with the Malad, if they want to prosecute, let them prosecute. I'll face it.
Whether you give us the names, not names, they give it or not, we will direct
No,
it.
I will make a further inquiry, Malad, and I'll file an affidavit. On Monday,
We Lakshman, the senior counsel, would submit that the drain which has been built by utilizing the funds of the Public Works Department to connect to a Rajakalwe.
Narega,
Narega.
National Rural Employment Guarantee.
ಅದು ಬರೀ ಇವ್ರಿಗೆ
Head of account, page
68 head of account ಅದ.
I'll just read it.
ಇದು
Detailed estimating provided under drainage system to the road from Isheke building to the Rajakalwe via Narayan Swami Circle and Chandrapura South and Shantipura village in Shantipura Gram Panchayat in Sarjapura Obli Anekta. Estimated cost of 9.2. Then head of account is national
building to Rajakalwe. How can you do this? Panchayati Raj engineering section.
ಇದು ಜಿಲ್ಲಾ ಪಂಚಾಯತ್
ಶೆಟ್ಟಿ ಎಲ್ಲ ಪ್ರೈವೇಟ್ ಬೆನಿಫಿಟ್ ಇದೆ. PWSSB ಏನ್ ಸಿವರೇಜ್ ಕೊಟ್ಟಿಲ್ಲ, ಆ ಸಿವರೇಜ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಈ ಸಿವರೇಜ್ ಮಾಡ್ಬಿಟ್ಟು ರಾಜಕಾಲುವೆ
ಕರೆಕ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ.
You pay 68 ನೋಡಿ, you are heading of the this given by section of the Panchayati Raj engineering section. Detailed estimate providing under drainage system to the road from Shekhar building to Rajakalwe via Narayan Swami Circle and Chandrapa's house. All public funds being used. And you connect a sewerage to a Rajakalwe. That is why all these things happen. The floods and everything. If you connect it to a Rajakalwe, it still till the Indian Nagar. Everything will get blocked.
conducted as another. And it was that water suddenly what goes to lake under.
Admitted, but who made that charity? Under the public, the Panchayati Raj engineering section, government. So all these people will have to be prosecuted. That is what we'll order further investigation.
Whether that time an inquiry whether this very investment, sorry, the spending of the public money is legitimate, then whoever is responsible, I am also joining.
Who proposed this project to connect sewerage to the Rajasthan? Fresh water ಇದಕ್ಕೆ sewerage connect ಮಾಡಿದ್ರೆ ಹೆಂಗೆ ಎಲ್ಲ ನಮಗೆ ಬರುತ್ತೆ ನೀರು ಕುಡಿಯಕ್ಕೆ.
ನಾನು this layout not where this human is and this project has been done. After this layout, there are other two layouts. 10 village, 10 mallards are lake. That is how I have been.
We will direct this inquiry and we will refer this to the Chief Justice to treat it as a public interest litigation. Because wherever this kind of connectivity is being made of sewerage to a Rajasthan, you may be, your petitioner may be a very small cop, you may get away, but there are so many people.
It may be a tip of iceberg, but something may also.
Especially with what happened now in the last 2 weeks ago. If the Rajkalve with sewage andre hogi ella ಕೂತಿರುತ್ತೆ ನೀರು ಎಲ್ಲಿ ಹೋಗುತ್ತೆ?
That is how we are facing. The Mandya having directly filed an affidavit.
By the with the permission of the Panchayati Raj Department, and the funds have been released under the head of account, inverted commas, National Rural Employment Guarantee Scheme, works 2009-10. Upon inverted commas, detailed estimate providing under drainage system to the road from Shekhar building to Rajakalve via Narayan Swami Circle, page 68, and Chandrapa's house at Shantipura village, in Shantipura Gram Panchayat, in Sarjapura Hogli, Anekal Taluk, inverted commas closed. It is not understood as to how a sewerage could be connected to a Rajakalve, thus polluting the same. The defense of the petitioner is that the said action has been taken by the concerned authorities. The petitioner cannot be held responsible for the offences alleged against him, and as such the proceedings are to be quashed. I am of the considered opinion that merely because government authorities were to make use of public funds to form a drain to connect to a Rajkalve, thereby committing an offence under section 277 and 278 of the IPC, the proceedings cannot be quashed. The investigation which has been carried out and the charge sheet laid at Annex L does not take into consideration these factors and has only taken into consideration is the allegation made against the petitioner. Therefore, there will be a requirement for further investigation to be carried out. Let senior counsel seeks for 2 days time to provide. ಏನಂತ ಹೇಳೋಣ Mr. We don't want to embarrass him. Seeks for 2 days time to file an affidavit as regards who are the officers and or authorities will sanction the same. Released on 19th or 21st. 21st September at 2:30 p.m.
Meanwhile, as one application, including the late government authority, competent authority.
ಅದು PLL ಆಗುತ್ತೆ.
Really active. Let them also give a report to the last.
Israel was. This we can't do. Except for suo moto.
Money to be given, the car to be given, that's the matter that we. And that's taken of the car. In 5 years, the car is going in Shankar. My senior counsel already, senior counsel had made a mention. 1 lakh I will find out from the company what he has said. So that I have consulted the party, 1 lakh in the case, they will give back the vehicle, 5 years old, lying in the junkyard. So I don't know how much money I have to spend on the car. I will do that on myself. When the laptop was there in the car along with the tripod of the camera, tripod is a very laptop is there, that I will return back and tell you. Those terms are agreed and
ಏನು instruction? No next week. ಮಧ್ಯಾಹ್ನ ಇದೇ 3 ಸತಿ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ ಇದಕ್ಕೆ. ಆಮೇಲೆ ಬಂದು ಹೇಳದಲ್ಲ. You are so, despite all your illegality, they have agreed to come and settle. We will dismiss your petition. You obtained an order from an arbitrator without even notice, without even approaching this court. Appointment of arbitrator itself is bad. And then you go and seize. Some settlement has happened, adukunu you afternoon, password. Senior ಬೇಕಾಗಿಲ್ಲ ನೀವೇ ಏನ್ ಒಂದು ಲ್ಯಾಪ್ಟಾಪ್ ಕೊಡಕ್ ಸೀನಿಯರ್ ಬೇಕಪ್ಪ. ಇವಾಗ ಆಯ್ತಲ್ಲ ಒಂದು ಲ್ಯಾಪ್ಟಾಪ್. What happened in the past? One laptop ಕೊಡಬೇಕು, ಕೊಡ್ತೀರಾ? ಆಯ್ತಾ? ಕಾರ್ 1 ಲಕ್ಷ. ಫೋನ್ ಮಾಡ್ರಿ. You have made a submission that if you give some money, we will release the car. So, the counsel for the petitioner submit that the petitioner is willing to hand over the laptop to the respondent at any time convenient to the respondent. The counsel for the respondent submit that he is willing to make payment of a sum of ₹1 lakh for release of the car. The counsel for the petitioner seeks for and is granted 2 days time to make a submission thereon. We list on 19th at 2:30 p.m. ಏನ್ ಎಂಟ್ರಿ ಮಾಡೋಣಪ್ಪ, ಕೊಟ್ಬಿಡಿ. Readiness and willingness is in doing, not in saying. So do it. Yes, Mr. But mic mute ಅಲ್ಲೇ ಇತ್ತು. ಎರಡು ಜಾಗದಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ರೆ ಇವಾಗ BV ಪಾಟೀಲ್ ಇಲ್ಲ. ಕರೆಕ್ಷನ್ ಏನು
Date correction ಆಗುತ್ತೆ.
ಏನ್ ಡೇಟ್ ಏನ್ ಕರೆಕ್ಟ್ ಆಗ್ಬೇಕು? 27.
2027 ಆಗುತ್ತೆ.
ಸೊ ಏನಾಗ್ಬೇಕು?
13/4/2015 ಆಗುತ್ತೆ.
ಏನಾಗ್ಬೇಕಲ್ಲ ಡೇಟ್ ಹೇಳಿ.
I was thinking to
ಅಪ್ಲಿಕೇಶನ್ ಕಾಪಿ ಸೇವ್ ಮಾಡಿದ್ರ ಪೇಪರ್?
ಅದನ್ನ in the office
The counsel for the petitioner has filed an application in IA1 of 2022 seeking for correction of the order dated 20th July 2022. It is submitted by NRT. There is a typographical error in line 2 of paragraph 2 of page 3 of the order dated 20th July 2022. Inasmuch as the date has been wrongly shown as 13/13.04.2027 when it ought to be 30/04/2015. And in paragraph 4, paragraph 4 ಏನು ಬೇಕು? annexure prayer ಇದೆ ಅಲ್ಲ, annexure ಬೇಕಾಗುತ್ತೆ.
make sure R2 ಆಗಿ they have produced that award copy as annexure R2. ಅದನ್ನ in fact the has said that is the award date.
We submit that there will be better clarity if after at the end of paragraph 4 the words inverted commas and as per annexure R2 are inserted.
They themselves have to do it. They didn't give the copy. They were not intact for copy because it was not.
In paragraph 5, line 3, the dates to be corrected from 13.04.2015 to 30.04.2015. Accepting the submissions, the application is allowed. Registry is directed to correct the date in para 2, line 2, from 13/04/2027 to 13/04/2015. Add as per annexure R2 at the end of paragraph 4 and correct the date in line 3 of para 5 from 13 to 30 and issue fresh certificate copy. IA1 of 2022. Where's Mr. Chalke? Where's Mr. Commissioner?
But the first matter pertaining to issue number 2 is club with this WP 5024 of 19. That is by the issue number 1. When this criminal petition 2090 of 1725 the matter was under investigation.
2093 ಅಲ್ಲಿ ಚಂದ್ರಶೇಖರ್ ಅವರು ಹಾಕಿದಾರೆ, ಹರ್ಷ ಅಂತ ಏನಾಗಿದೆ ಇಲ್ಲಿ? Where are either of them? Both of them are not here.
But in the second matter, there is a state pertaining to the first matter. Lord, the first matter, Lord, is the right. Lord, no references.
No arguments in their absence. We'll put them on notice and then take.
Meanwhile, Lord, permission. Lord, when this first petition, the petition will be filed, matter of investigation. Subsequently, that too, she has been submitted. But Lord, in WP, Lord, when the matter was paid by the honorable court, Lord, the charge sheet was, Lord, I will be permitted to carry out necessary amendment. Anyway, Lord, in view of the case.
You want to file amendment?
Amendment, Lord, wherein the version of charge sheet.
Fresh petition act is,
They already tagged with it. There is no.
Because what happens we have seen is whenever these amendments are carried out, it results in a lot of confusion when you argue. It is in your interest that the fresh petition is filed. If you want to amend, we have no problem. We permit you to do that. File your application, you do that.
Then it will be tagged.
2093 will give you liberty. Criminal petition number 2093 of 2017, the same is dealing from so and so. The counsel for the petitioner submits that post the filing of the above, while the above matter was pending, a charge sheet has been laid. He seeks permission to withdraw the above matter with liberty to file a fresh petition challenging the charge sheet. Reserving such liberty, criminal petition number 2090 of 2017 is dismissed as not pressed. Idenu 9.1. Relist on. No orders need to be passed in them. Interim order. 9.1. Relist on 1710. Number 3, told you. Let me join them. Your name is not shown. Sri Madanam Pillai, the council submit that he had appeared for respond number 3 and 4. However, the name of the earlier council, Srimati K. Anasuya Devi, is shown in the order. Registry is directed to delete the name of Srimati K. Anasuya Devi and instead print the name of Sri Madanam Pillai as that appearing for respond number 3 and 4 and issue a fresh certificate.
May I take this opportunity? I have not moved the number of these. Connected below this petition 86719. Then I had challenged the order of the appellate authority. This is my appeal. Otherwise, the order of the appellate authority will have to be a separate order, will not go on the same order.
Then you have to make an application. It's not put up with it.
The resolution was the application on the interest portion which are not granted.
8617. After objection. Sir, my dear.
He proposes to file. He files
and proposed. The first application file, Madi, or objection, no, then we'll consider it. Now your application only is not there. Sale number 2. Your standard order, refer to number Ch-15. Three for it. Shaker accept notice for responding. Both the council submitted matter to be referred. Ramesh and accept notice for responding. Both council submit. 5. Shaker is appeared. Delete the name of Shri Abdul Sharif as that appearing as party in person. Both the council submit. Appearance. Last year out appearance. 21/9 appearance. 29. 6 board council submit, 7 board council submit, 8 Sri SB Shrikant accept notice for responding, delete the name of Shrikant, board council submit. 8.1 SB Shrikant accepts notice for petitioner. councils submit. 9 board councils submit. 10 board councils submit. 10.1 L Shaker has entered appearance for respondent. Delete GVP Reddy, board council submit. 11 board council, 12 board council, 13 board council, 14 of them. KSRTC is that. 14 Sri L Shaker accept notice for R1 board council submit. 15 board council, 16 L Shaker accept notice for respondent board council submit.
ಇಲ್ಲ ಪಕ್ಕದ ಜಮೀನಿಗೆ
ಅದೊಂದು ಸರಿ ಮಾತ್ರ ಮಾಡಿ ಸಿಕ್ಸ್ಟಿ ಅವರೇ ಮೇಡಮ್ ಸಂಜೀವ್ ಬಿ ಅನ್ನು ಈಗ ಅನು ಹೋಗಿದ್ದಾರೆ ನಮ್ಮ ಫ್ರೆಂಡ್ ಸೇಮ್ ಕಾಪಿ ಸೇಮ್ ಅವರು 72 ಅಷ್ಟು ಅಯ್ಯೋ ಅದೇನಾಯ್ತು ಇದೇನಾಯ್ತು ಅಂತ ಕೇಳ್ಕೊಂಡ್ಬರ್ತಾರೆ. ಹಿಂಗಲ್ಲ ಇದು ಸಾಧ್ಯ ಆಟ ಏನಾದ್ರು ನಾಳೆ ಕಾಫಿ ಅದೇನೋ ಒಂದು ಬಿಚ್ ಕೂಡ ಕೇಳಿದ್ರಲ್ಲ ಮುಂದೆ ಆಮೇಲೆ ಏನು ಮಾಡೋದು
ಇಲ್ಲೇ ಇದೆ.
I was remember I had in mind when we were arguing. When he said not before me, then hello, court officer. He's list commit sir. Court officer. Court officer.
Sir, ಹೇಳಿ sir.
Serial number 33. Cyber not
ಯಾವ
before
ಲಿಸ್ಟ್ ಸರ್? ಯಾವ ಲಿಸ್ಟ್ ಸರ್?
list 1. List 1, madam.
ಅಲ್ಲಿ 33 ನಾಟ್ ಬಿಫೋರ್ ಮೀ ಅಂತ ಅಂದ್ರು ಸರ್ ಅದು.
ಹೌದು ಮೇಡಮ್, ಹೌದು. ಅದರಲ್ಲಿ ಇಂಟರ್ಮೆಟ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಬೇಕಾಗಿತ್ತು.
ಹೇಳಿ ಮಾಡಿಸ್ತೀನಿ ಸರ್ ಅದು.
ಆಯ್ತು ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
तो फिर 9 को कोर्ट बिजी था, 9 को कोर्ट का कोई और शेड्यूल चल रहा था, तो फिर अब वो हियरिंग आज की हुई है। तो आज बस उसमें ये बताना है कि मैं नोएडा चूज कर रहा हूँ या मैं दिल्ली चूज कर रहा हूँ या मैं आर्बिट्रेशन वापस ले रहा हूँ। उसके पास 3 ही ऑप्शन थे, कोई चौथा ऑप्शन ही नहीं है। और करेगा ये क्या? मतलब वही कि मैं केस वापस लेता हूँ बेसिकली, या तो केस वापस लेगा या नोएडा या दिल्ली लड़ लेगा और फिर
Yeah, I found it. Yeah. Only
ಈಗ ಮುಚ್ಚಿಟ್ಟು propose ಮೇಯೋ ಹಾಲ್ ನಲ್ಲಿ
You have ideas for? What are you saying, really? What day? 24, 25, 26. It's fixed. When today? What's the dates again? What did you say? 24th? October? Oh wow. Dude, it's actually 5 days. Abhishek, it's 5 days.
Like as in Diwali and Diwali over the puja.
It will be there in that criminal files or something like that. Just check.
Namaste, sir. Good afternoon.
Namaste, madam. Complete. Finally. We present and all agade kelsa. First ಹೇಳ್ಬಿಟ್ಟಿದ್ರೆ first ಹೇಳ್ಬಿಡ್ತಾರೆ. They didn't want to come. No respect for the order. They were counsel for both the councils submit that the order against which the contempt proceedings have been filed has been finally complied. There is no further order is required to be passed. Complied ante madam full.
Yes, sir. Yes. Thank you. ಫಾಸ್ಟ್ ಲೋಕ ಅದಾಲತ್ ಮ್ಯಾಟರ್ಸ್ ಆಮೇಲೆ ಬೆಳಗ್ಗೆ ಟ್ರೈನ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ನಂಬರ್
So number one, both councils submit. The date of 21st, 21st or 29th. Second one is Mr. S.B. Srikanth was entered up to respond. Vivek Kotan. 2.1 million. The S.B. Srikanth is directed to accept notice for the petitioner. Accept notice for the petitioner, delete data. Both councils submit work report.
Passport matter. Number one. Figure number 24.
Joined at the outside the voting parties.
Yes, madam. What are the terms of settlement? Have you agreed? Have you settled? What are the terms of settlement? You have received 5 lakhs. You are in check or demand draft?
Demand draft for 3 lakhs is ready. As per the terms, it has to be handed over. Handing over.
Any other claims? All your jewelry, everything you have taken return of? All your jewelry and everything you have taken return? Anything left? No, nothing.
Petition is ready. Second petition is the parents and the sister of the first petition is
One 1006 for 2000, petitioner is before the court seeking for the following 1007, seeking for the following. The petitioner in criminal petition number 1006 of 2018, which is the husband. The petitioner in criminal petition number 1007 of 2018 are the father-in-law, mother-in-law, and sister-in-law of the complainant. The complaint has been filed as regards offences under section 498A from 506 of the IPC, regular section 3 and 4 of the Dowry Prohibition Act. The dispute between the parties arises out of matrimonial. The proceedings between the parties arises out of matrimonial disputes. MC number 6271 of 2018, which had been filed by the husband seeking for divorce under section 13(1) bracket 1A 1B of the Indian Marriage Act 1955, upon being referred to mediation, has been settled between the parties. One of the terms of the some of the terms of the settlement are that the petitioner, the husband would make payment of a sum of rupees 5 lakhs to the complainant, out of which a sum of rupees 2 lakhs has been paid at the time when the settlement was entered into, and the balance sum of rupees 3 lakhs is to be paid when the complaint cooperates with the petitioner for quashing of the criminal proceedings initiated by the complainant. The complainant response number 2 is before this court, and on inquiry she submits that the dispute between the parties has been amicably resolved and the divorce and the marriage has been resolved by decree of divorce. She submits that she has already received a sum of rupees 2 lakhs, and she confirms receipt of a sum of rupees 3 lakhs by way of demand draft bearing number 046510. Dated 17/8/2022, drawn on HDFC Bank, Madhepura branch, Bangalore. She submits that she has no further claim or complaint against the petitioners in both the matters, and that the proceedings against them will be dropped by allowing the above petition and quashing the criminal petition, the criminal complaint. In view thereof, I pass the following order. The FIR in crime number 231 of 2017, registered by the Whitefield Police Station. Consequently, the charge sheet dated 17/6/2017, filed in CP number 9498 of 2017, pending on the file of the first additional Chief Judicial Magistrate, Bangalore, as also all orders passed therein are hereby quashed. Common, same one day. 46. What the council said is you are not cooperating. Are you willing to cooperate? So by when? 36, both the councils submit that they are discussing settlement. If a week's time, if some time is granted, if a short time is granted, settlement would be reported. Released on 21/9.
Okay.
List number 2, serial number 12, my lords.
Yes, Mr. Chairperson.
2 weeks time, my lords. In fact, I had to get in touch with the client insofar as the interest is concerned. For some reason, not able to get in touch, my lords. The phone is also not.
Have you informed the petitioner?
I have informed
copy of the petition in this matter, Your Honor.
petitioner. I have spoken to the petitioner's counsel, my lords.
The counsel for respondent seeks for and is granted 2 weeks time to make his submission on the interest payable on the settlement arrival, released on 14/10. Any other mention?
Hello.
Notice to respond has been dispatched on 15/9, awaiting services notice released on 21/10. Registry is directed to put up the postal tax record by them. Mr. Satish Chandra. Any other proceedings pending? Section 9 in our area. Section 9 only. WhatsApp. Section 9. Section 9 proceedings in our area. Injunction proceedings in area. And counsel for the petitioner submit that the respondent is intentionally delaying, avoiding service of summons. Registry is directed to issue notice to the respondent. By email. What is the address? What is the address? Email address?
I will furnish you.
Page 43. 4, 6, 7, 1, 4, 5, 6. Page 43. Informing the respondent that the matter is now next listed on 14th October 2022. We list on 14th.
Petitioners by me, my lord, serial number 3. In this, my lord, the joint development agreement has been entered between petitioners number 1 to 5 with petitioner number 6, my lord. And pursuant to the joint development agreement, as per the sharing agreement, the flats that have been allotted to respondent number 6, agreements have been entered in favor of the petitioners and other purchasers, my lord. And there, in that agreement, there is an arbitration clause which has been breached. So that clause has been invoked, my lord. By oversight, those agreements have not been produced. If your lordship could grant a week's time, I will produce those agreements.
Counsel for the petitioner seeks bond is granted 2 weeks' time to produce certain other agreements entered.
Agreements, please, my lord, please.
To satisfy the office objection raised. Please. On 14th.
Obliged.
Lord, I appear for the petitioner in serial number 4. Lord, the office objection is, my lord, that there was no agreement. My lord, annexure A, my lord, shows the terms of an auction where there is an arbitration clause.
You are supposed to produce acknowledgement for service.
Yes, my lord. That is filed, my lord. That is filed on 8th September 2022. Please see, my lord, the postal receipts are there. Notices have been sent, my lord, to both the respondents.
Acknowledgement tag, Mr. Abhinav.
Lord, acknowledgement is not received. My lord, there's a reply that has come, my lord.
Where is the reply?
My lord, reply, my lords will kindly get at annexure E, page number 55.
55. This is as regard the first respondent. What about second respondent, Mr. Abhinav?
Second respondent, my lord, notice is sent, no acknowledgement is received. My lord, the sending of the notice, my lord, had to be done within the time period fixed by the division bench, my lord.
Without
that is why, my lord, that was
or a postal track record, we can't accept your submission.
I'll try to secure the postal track record, my lord, because since it is already 3 months, there will be no postal track record, my lord. I'll make inquiries and I'll submit it. I'll furnish it.
Seeks bond is granted 2 weeks' time to produce the acknowledgement of service on respond number 2. That is what was the order last time. Again,
Very well,
Lord.
Yes,
it is made clear that if the acknowledgement is not produced, the petition will be liable to be dismissed on the next date of hearing. Leave it on 30th September. They're not giving you the copy.
That copy may not be
What do you start for? What do you start for in this man?
Annexure B, there is observation by export that I have taken because they are not with the objection. Annexure B, page 46 minutes. 48 minutes. Because the dispute that arrest before learning signature. And at the time of disposal of the arbitration, clause also are invoked in section 38, the clause 38 also, the liberty is granted to invoke the jurisdiction of the district judge also. Because when I say first proceedings, the ordinary gas leader. It is hoped that both sides shall choose a competent arbitrator and the district judge 48. Right? They said that you consent may not. The arbitration district judge may not having a certificate Mangaluru, and you can also do the job.
You filed your statement of claim.
By the
respondent.
Yes.
Without the arbitrator being appointed.
Before that, before the learners in the yet after hearing the both parties, because I have suggested that the arbitration proceeding will be possible because these are ordinary regular gas. Arbitration it will not be.
Then what do you want from this?
ಚಾನ್ಸ್ ನೋಡ್ತೀನಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಒಪ್ಕೊಂಡ್ರೆ ಕೆಲಸ ಆಗುತ್ತೆ ಮಂಗಳೂರಲ್ಲಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕ್ಯಾಂಪಸ್ ಮಾಡ್ತಾರೆ. I have preferred the decision who is conducting the proceedings at Bangalore. This observation also I took it from the learning center at the time of disposal of that. I don't dispute my arbitration is there, but the dispute has once came before the learning before the Islam court. At that time of the talk of compromise going on. By that time, at the time of the invoking the clause 30 of the arbitration agreement, I suggested because of company arbitration, I cannot approach it to Bombay because they are going to be Bombay. So that may not which I suggested that
the clause that you extracted says it is Mangaluru. Clause in Mangaluru, Bombay can go. Or more than a bacon. Issue notice pending compliance with the office objection, issue notice to respondent. Returnable, standing counsel added.
That may be deferred because they asked, the office is asking for the order sheet of this program.
Standing counsel added.
In the petition may not NJ Kumar has said.
NJ Kumar, standing counsel for respondent is directed to accept notice for the respondent. Petitioner to furnish copy of the petition along with annexures on the said counsel. Objection written by 14, released on 21st.
Do the needful.
Counsel for the petitioner submits, you will furnish the necessary process fee, you will do the needful by end of day tomorrow. If the needful is done, registry is directed to issue notice to respond number 1, returnable by 2/11/2022, released on 2/11. Sorry, 4/11. One party agreement is with the company. ಮಾಡಕ್ ಬರಲ್ಲ ನೀವು ಮಾಡಿರ್ಬೋದು. We won't accept that. We will issue notice to respond number 1. ಆಮೇಲೆ ಅವರು ಅವ್ರ ಗಂಡ ಅವ್ರ ಮಗ ಎಲ್ಲಾರನ್ನೂ ಕರ್ಕೊಂಡ್ ಬರಕ್ ಆಗಲ್ಲ. You can't arrest people. Registry has raised an objection as regards the arranging of respond number 2 and 3 as parties to the present proceedings on the ground that there is no party represented by representative cannot be made a party. I am your order sheet al barutte so and so represented Mr. Harish HB anta nimman party madibirtare appeal alli on the ground that respondent number 2 and 3 are not parties to the joint development agreement dated 27/8/2009. The counsel for the petitioner submit the respondent number 2 and 3 are the managing director and director respectively of respondent number 1 as such they have been made a party. The said ground, the said contention is not one which can be countenanced either in law or fact. Arbitral proceedings can only be initiated among the parties to an agreement. Respondent number 2 and 3 not being parties. The proceedings, the office objection is upheld. The proceeding against respondent number 2 and 3 stand dismissed. In notice of ಕೊಟ್ಟಿದ್ದೀರಾ? ಅಲ್ಲ, ನೀವು ನೋಟ್ arbitration clause invoke ಯಾವಾಗ ಮಾಡಿ? Arbitration clause ಇದೆ.
Page number 25.
25.
Condition 22. In case any dispute arises between the parties.
Yes. ಎಲ್ಲಿ invoke ಮಾಡಿದ್ದೀರಾ?
Hello. Yes.
Page number 37.
ಹೇಳಿ.
ಯಾರು ನಾಮಿನೇಟ್ ಮಾಡಿದ್ದೀರಾ? Who did you nominate as arbitrator? You not nominated anybody. The 3 arbitrator panel, you have to nominate your arbitrator. Arbitration husharagirbekku, it has to be. We will dismiss this, reserving liberty for you to issue fresh note. Next week ಆಗಲ್ಲ, notice ಕೊಡ್ಬೇಕು, ನೀವು nominate ಮಾಡಬೇಕು. ಆಮೇಲೆ ಮತ್ತೆ ಅವರು ಒಪ್ಪಲಿಲ್ಲ ಅಂದ್ರೆ ಬರ್ಬೇಕಾಗುತ್ತೆ. The petitioner and first respondent entered into a joint development agreement dated 27/8/2009, which is bound an arbitration clause in terms of clause 22 of page 25. The petitioner claims to invoke the arbitration clause by way of this letter, notice dated 29/4/2022 on account of disputes which are arising between the parties. A periodically said notice indicates that the petitioner has only indicated that if the demands made are not complied with, the petitioner would proceed in appointing an arbitrator for recovery of interest and damages in accordance with law. No particular arbitrator has been appointed when, in terms of clause 22, the arbitration is required to consist of 3 arbitrators, one appointed by both the parties and the presiding arbitrator to be appointed by the arbitrators so appointed. There being no compliance with clause 22 and no arbitrator having been appointed, the present proceedings are premature and could not be filed. Hence, reserving liberty to the petitioner to issue a fresh notice nominating its arbitrator, and if the same is not accepted, to approach this court, the petition stands dismissed. Yes.
Today I'm reading because of communication gap.
Counsel for the petitioner.
One of the has not been represented by the holder, that is the respondent number.
Order 43 will not apply to this. You'll have to serve the notice.
Now, he was represented by the respondent 7 and 8.
Or Bandilla, if they had come and accepted no service, then it is fine. We could have asked them if they would accept service. Or Bandilla, Mr. Bhatt, the arbitration. If they don't come here, they won't come to arbitration. And there's no purpose which should be served. Counsel for the petitioner submits that he has made payment of necessary process fee. Agency is directed to issue notice to respond number 1, returnable by 4/11/2022. Counsel for the petitioner seeks for and is it a proprietary concern or a? The counsel for the petitioner submits that the petitioner is the proprietor of Dal Alcobev, which is a registered proprietorship firm. Registered where? Where is the registration document? How do you say a proprietorship is registered? Under what provision? You said it is registered proprietary concern. That is why the office also is asking you this question. Then you have to amend this. You said everywhere is registered. Page 30. 1-3. Yes.
Service provider of the lordship will look at the definition of the second part, which is the profession concern.
What you have described is wrong in the petition. That will have to correct. Anyway, we'll let you notice. Counsel for the petitioner submits that the petitioner is a proprietor of the Dal Alcohol. By inadvertence, it has been shown as a registered proprietorship firm. Where is firm also you use? That's where the problem. He submits that the same is by mistake and necessary application for amendment to be filed. Pending the same, issue notice to. Where is the arbitration clause?
The arbitration clause on page number 22, clause 14.2.
Where is your request for conciliation?
Lord, I have sent certain emails.
Where is the request? Where is the request?
Lord, I'm sure the arbitration notice that I have issued.
Where is the request for conciliation? Amicable resolution of the matter by conciliation.
Lord, there was one notice issued now. I'm sure J.
Page 70? Yes. Where is the notice for conciliation, madam?
Lord, I'm sure B.
Page?
Page 59.
Where does it say conciliation? Have you issued a notice for conciliation or no?
No, my lord, not conciliation.
If you are not issued, then you issue that. Then only you can raise the arbitration.
No, my lord.
Is there any document, madam? Please show us.
My lord, there are DAs only that is trying to say that we have an issue with not.
The petitioner is before this court, seeking for the following release.
I'm sure B, my lord.
The petitioner and the respondent are entering into a service provider agreement which is bound by an arbitration clause in terms of clause 14.2, which is reproduced here under page 28. The petitioner claims to issue a notice invoking the arbitration clause on account of disputes which are arising, and the respondent not having agreed for arbitration is before this court seeking for appointment of an arbitrator. The Peruvian clause 14.2 indicates that the party shall endeavor to resolve the dispute or differences in an amicable manner through mutual consultation. And if no settlement is reached, then a written notice invoking the arbitration clause has to be issued, and thereafter it is the respondent who has the authority to appoint a sole arbitrator. And only in the event of respondent not appointing an arbitrator could each of the parties appoint an arbitrator, and those two arbitrators to appoint the presiding arbitrator. Despite inquiry, learned counsel for the petitioner is unable to point out any document to establish any effort made for amicable resolution of the matter and mutual dispute and mutual consultation. Yes.
The last third paragraph. The next sentence is saying that it will also, I mean, read out.
Page
71 to 70.
71, yes.
71, however, the last third paragraph. Considering associated with over a decade now and having given full cooperation and non-respect in all these years, we would appreciate that the service charge commission and losses sales have achieved the last 2 years to be reimbursed. And the service charge.
This is all your demands, madam. Please follow the clause.
But we've not received any response from the respondent.
You are not even asked for conciliation. Please follow the clause. Do that. Mutual, by mutual, amicable manner to mutual consultation, nor any notice has been issued seeking for the respondent to appoint an arbitrator. The petitioner has directly issued a notice appointing its own arbitrator without following the terms of the arbitration clause. In view thereof, I am of the considered opinion that the same is not a proper invocation of the arbitration clause, reserving liberty to the petitioner to comply with the arbitration clause seeking for mutual consultation, the amicable resolution by mutual consultation, and thereafter complying with the requirements of clause 14.3 above. The petition stands dismissed. Page number?
That's a bill. Indian staffs and registration. Click on the term.
Page number 15.
Act to amend an Indian stamp and registration. Not the whole act. I tried searching for it. I couldn't find it. There's no proper PDF of that particular thing.
Counsel for the petitioner submits that the purchase order has been exchanged by way of email, and that's it. There's no original.
This guy is here only, no? The Bisani.
Madam, please mute yourself. Accepting the submission, office of objection at sale number 3 is overruled. Where is the arbitration clause?
Page number 16.
Where is your invitation? Issue notice to respond written out by 4/11/2022.
My lords, I appear for the petitioner in this matter, my lords. In the present case, the office objection has been risen that the original copy of the arbitration agreement has not been produced before this honorable court. The said agreement is in the safekeeping of the petitioner since there is another civil suit that has been pending between the parties for suit for rejection. This agreement is arising out of leasing out a
The
session.
original agreement is produced in court or is in the custody of the respondent?
It's in the custody of the petitioner itself, my lords. But it is in Tirchi in his hometown. He is a permanent resident over there. There is another connected matter pending between the parties. And hence he would be needing a copy of that to be produced before the trial court as well.
You produce it here and then take return. You can't just hold it on to yourself.
My lords, I would comply with that. I can produce that at a later point of time. However, in the present matter, the respondent has been a habitual offender and several cases have been pending against him.
Bisani, don't make allegation before complying with your objections. Either you have an option to file a dispensation or comply. You can't keep the agreement.
I will file an application for dispensation, my lords. The matter may be listed next week.
For 2 weeks, released on 14/10.
My lords, a shorter date, my lords. I would seek your indulgence. The property is something that
This objection has been raised quite some time, so please produce it.
2 days, my lords. Therefore, yesterday we had filed the case. If a shorter date is granted, 14, 10, or any other next week, any date.
1410 is what has been granted, Mr. Bisani.
Sorry, the 20th of September, 29.
So next year. What service already? Yes. But the problem is, the risk is if they don't come there.
I know they have already 20 tracking from the month of 6. May itself it has been served on. He's received it and it's not. It's not even replied from my legal notice.
Yes, where is the agreement?
Madam, the clauses at page 7, page 7. Clause
7.
26.
Page 7 is your petition, madam. Page 9. Clause?
Internal page 5, the clause 26.
Where is your invocation?
My notice for that is page 17 and it should be. And I call upon to settle the dispute, page 25. And then I issue one more notice. We received this also. I produced the draft thing. Then I issued one more notice for the appointment of an application. And it should be. My appointment is page 32. I have suggested.
The petitioner is before this court seeking for the following release. The petitioner and the respondents are partners who had entered into a partnership deed dated 27th October 2014, which is governed by an arbitration clause in terms of clause 26, which is reproduced here under the easy reference, page 13. There being certain dispute between the partners, initially a notice dated 18/8/2021 was issued to the respondent, making a claim of certain amounts of money which was not paid. As such, yes.
Give a 4 weeks time, I have instructions to it.
What objections do you have?
The appointment of an application, applicator and the dispute itself.
On the dispute you can't. What is it? Are you disputing the agreement?
And also the appointment of the process that is important for the appointment.
The process is simple, it's been followed. What is your objection?
The dispute itself and as well as
Dispute, you raise it before the arbitrator.
and compliance with the terms of the partnership.
It has been complied. You don't find anything. You don't waste the time, let it go. Subsequently, which has been received. Subsequently, another notice dated 11/10/2021 has been issued, nominating the arbitrator. Despite service of the same, the respondent not having appointed its consented to the appointment of an arbitrator or suggesting an alternate arbitrator, the petitioner is before this court. Upon service of notice, service was held sufficient. Today, Shri submits that he would be appearing for respondent. He submits that the petitioner has not invoked the arbitration clause in a proper manner and the procedure has not been followed. And as such, the petition may be dismissed. Having gone through the arbitration clause, what is required is only for the petitioner for the parties to refer the matter to an arbitration. The arbitration decision is binding. There is no particular procedure which has been prescribed under clause 26, which has been extracted here and above. The invocation of the arbitration clause by way of notice dated 11/10/2021, in my personal opinion, is proper and correct. As such, I start the following order. Any choice of arbitrator that you have? We will give them the choice. And we will only. Petition is allowed to. What is the claim amount, madam?
1 crore 68 lakhs.
Sri S. Ramamurthy, the former district judge of the district judiciary of the state of Karnataka, is appointed as sole arbitrator to arbitrate the dispute between the parties under the aegis of the arbitration center. Director ownership, all contentions are left. Yes, Mr. Brown, any objection?
Last week, if I thought, notice of the year 2019.
Any objection? 28th January 2020, 6 months old dispose ಆಗಿದೆ ಅಂತ Supreme Court ಹೇಳಿದ್ದಾರೆ. You are already 8 months ಆಯ್ತು ಹೇಳಿ.
This last week I filed for 2019 is the notice.
Any particular objection is there? Not ಅಷ್ಟೇ. Unnecessarily. Yes, Mr. Oyo. Page 48. Where is the invocation? Where is the invocation?
Invocation is at 371 months. 21 is my notice. Also find it at 374. For Karnataka.
Yes. No reply?
Reply is may not use letter page 76. May not say that there is no dispute. And also find that para 17 not 81. If there is no dispute available, there's no question of that thing to ask.
Petitioner is before this court, seeking for the following relief. Petitioner and respondents had entered into a joint development agreement dated 19/11/2012, which is governed by an arbitration clause in terms of clause 20 thereof, which is reproduced hereunder for the reference, page 48. There being dispute which arose between the parties, the petitioner issued a notice calling upon the respondent to make certain payments on 22/3/2018. When the same was not acceded to, the petitioner invokes the arbitration clause and issued a notice dated 13th November 2019, appointing its arbitrator. On receipt of the same by the respondent replied by admitting the existence of the arbitration clause, but stating that in view of various factors, there is no dispute which is arising between the parties to be arbitrated. So it is in that background that the petitioner is before this court. The Vivek Kolla, the counsel appearing for the petitioner, would submit that the various notices, that the two notices which have been issued, making a claim, would indicate the disputes between the parties, more so when the same has not been paid by the respondent. Therefore, the respondent cannot contend that there are no disputes. The G.S. Venkata Subbarao, the counsel for the respondent, would submit that on account of various events which have occurred, there is no amount which are liable to be paid by the respondent to the petitioner, and that's why there is no dispute. Having heard both the counsels, I mean, considered opinion that when there is a claim made by one party and which is denied by the other party on account of events which have occurred, the very claim and denial is a dispute between the parties, which would be required to be arbitrated. After I pass the following order, petition is allowed. Yes, to what is the claim?
4.1 is claim error. Para 8, not 374.
Yes. No, we don't need to only roughly to see whether after. Any choice, any? You will
Was adjudicated by an High Court Judge Milord A.V. Chandrasekhar Justice.
Both the council submit that Shri A.V. Chandrasekhar, the former judge of this court, may be appointed as sole arbitrator. Shri A.V. Chandrasekhar, the former judge of this court, is appointed as sole arbitrator with the consent of both the councils. The director arbitration center to do the needful. All contentions are left open to the arbitration tribunal. Sanjay, any objection? Any serious objections? Serious. We have received it. You don't appear for the first respondent.
I don't appear for the first.
First
We are
respondent.
part of this investigation.
What is your objection?
But my objection is that the dispute is amongst the between the petitioner and the second respondent intersect. In fact, what the agreement provides for is kindly turn to page 32. This relates to publication of a book on the IIT, on the alumni of IITs of Karnataka. So what happens is the petitioner and the second respondent, first respondent come together, and they want the first respondent who might, second respondent who might represent to publish the book. So what the agreement is essentially only in the event of any there being any dispute between the authors of the book, that is the petitioner and the first respondent, and the second respondent, arbitrator can be appointed, the dispute can be resolved. Now in this case, the book was published, the book was substantially prepared, it was ready for publication. But by then, they amongst themselves, they quarreled and they have approached the court for an interim measure. So I have been restrained from publishing this book in the arbitration application. Now, these proceedings, they are seeking for appointment of an arbitrator. Now,
You may not be a necessary party. You may be a proper party, because you are also party to the agreement.
No, but what happens is this agreement is said to be between the authors and the publisher.
You also signed it along.
My lord, that's what my lord, can you take class 18 for a minute? 34, in page 34. I have also not signed the arbitration agreement. That's another thing, my lord. I have taken a specific defense that I have not signed. But however, the work that was assigned was accepted. That part I don't dispute. But I have not
Now you want to publish or not to publish?
No, I am the publisher. The books are ready. Now they are fighting and they are saying you don't publish it. I mean, like only one of them is saying that don't publish it. Kindly turn.
So that dispute has to be resolved for you to publish. You are the affected party.
Correct, correct. I agree. But what I am saying is they have to resolve their disputes not through arbitration, because the agreement is not amongst themselves interested. Yeah, the scope of arbitration agreement between the parties is only if there is a dispute between authors and publisher. It's not that I am disputing something.
But please understand, without that resolution, you will be holding on to the books in your warehouse. You want to keep it in your warehouse?
No, my lord. No, it's not like that.
So we'll make note of your submission.
Yeah.
But then we'll also observe that you won't be able to sell it until their dispute is resolved.
No, that is already.
We'll make note here also.
My lord, for a minute.
We'll accept your submission, accept it. We'll say that you can't publish it until their dispute is resolved.
No, but my lord, what has happened is.
You can't take advantage like that. But let them fight, I will keep publishing, let them keep on fighting. You can't do that.
No, I am not saying that I will publish, but what I am saying is there was no dispute at all between the authors and the publisher.
So you said you may not be a necessary party.
The author's interest.
You may not be a necessary party, you will be a formal party, a proper party.
My lord, my kindly listen to the arbitration.
ನೋಡಿ ಆಯ್ತು ಕ್ಲಾಸ್ 18 ಮೂರ್ ಸತಿ ಓದಿ ಆಯ್ತು 18 ಅಂದವ. We agree with you, but you are a proper party because you are a party to the agreement.
Right, just 2 minutes.
We will accept your submission, but you won't be able to publish. ಅಷ್ಟೇ ಹೇಳ್ತಾ ಇರೋದು ನಿಮಗೆ. We will reject the claim against you.
Now what happens?
We will appoint an arbitrator between petitioner and respondent number 1.
Yes.
And we will reject it against you, but we will observe that you won't be able to publish and sell.
No, that is anyway then.
We will observe it here also.
There is an order.
That is until now section 9 is the order agida illa arbitration illa anta helbiಟ್ಟು ಅದು vacate ಮಾಡಿಸ್ತೀರಾ. So we will put it here that you won't be able to do. That is the risk you take. You want to take it? ನಿಮ್ಗೆ risk ಅದು.
Only thing I wanted to, what I wanted to drive was unnecessarily the respondent is being, this respondent is being pulled into arbitration.
We understood the dispute. We understood.
That's all.
You can't take advantage. Petitioner is before this court seeking for the following reasons. The petitioner, the first respondent and the second respondent entered into a memorandum of agreement on 17/2/2021, which is bound by an arbitration clause in terms of clause 18 thereof, which is reproduced hereunder for easy reference, page 34. There being certain disputes, the petitioner invoked the arbitration clause while
Clause 18.
it's lesser dated. Where have we invoked which document?
Notice dated 38/2021.
38/2021. Appointing its arbitrator. The same can be replied to by the first respondent, stating that he does not accede to the appointment of an arbitrator. What did you reply?
It is a dispute amongst the authors.
Where did you reply?
Well, in case 123, next paragraph. On 29 May 2021.
Respondent number 2 also took up the contention. Replied on 29/9/2021, contending that the agreement is not signed by him and that they do not accede to arbitration. In the meanwhile, the petitioner filed proceedings under section 9 of the Arbitration Conciliation Act in A number 109 of 2021, seeking for injunction restraining the respondent number 1 and 2 from publishing the book subject matter of the agreement, which is bound by the arbitration clause, wherein an order of injunction is being granted. It is in that background that the petitioner is before the court
It was only an ex parte order. It is statement.
seeking for the opposite relief. We, Sanjay Krishna, and counsel appearing for respondent number 2, would submit that the dispute, if any, is between the petitioner and respondent number 1, and there is no dispute as such with respondent number 2. And it is the petitioner and respondent number 1 who had authorized to publish the book, authorized respondent number 2 to publish the book on the alumnus of IIT Kharagpur. The book being ready, the respondent number 2 is ready to publish it, but would not be necessary party for the adjudication of dispute between the petitioner and respondent number 1. Correct. The reading of the agreement indicates that the petitioner number 1 and respondent number 1 together enter into an agreement with respondent number 2 for publication of the officer's book. Now that there are disputes between the petitioner and respondent number 1, it is required for those disputes to be resolved by way of an arbitration, notice having been already issued, and respondent number 1 not conceding to the appointment to the arbitration, to the constitution of the arbitration. Respondent number 2 contends that he is not a party to the disputes, and the disputes are to be resolved between petitioner and respondent number 1. If that be the case, until the resolution of the dispute between petitioner and respondent number 1, the respondent number 2 would not be able to, cannot act on the agreement and or publish any book to the detriment of the petitioner. As such, the petition against the respondent number 2 is dismissed. Insofar as the petitioner and respondent number 1 are concerned, an arbitrator is required to be appointed. Hence, I pass the following order. Petition is allowed. V.N. Ravindra, a former judge, district judge of the district judiciary, Karnataka district judiciary, is appointed as sole arbitrator. 3 arbitrators. Who had you nominated? Is appointed as an arbitrator on behalf of respondent number 1. The said arbitrator, in consultation with the arbitrator appointed by the petitioner, and the arbitrator appointed by the petitioner is from Calcutta. He will pay the cost. And a letter dated and under the notice dated 30th of August 2021 shall together appoint the presiding arbitrator to arbitrate the dispute between the parties under the aegis of the arbitration center attached to this court. We direct the arbitration center to do the needful. All contentions are left open. Yes. That is not the submission you are required to make. The question which was posed to your friend who had appeared was, are you agreeable for Gurgaon or not? You are not agreeable, but then we'll appoint him. Yes. Yes.
So sorry to interrupt. My learned friend is not audible to me because he is not speaking on the mic. Sir, please. I'm sorry I interfered.
Mike, speak into the mic.
Judgment, my lord, case number 6.
Yes. Have you given this judgment to the other side? How can you rely on something which without giving you something?
Yes, sir, I have not received.
You read point number 2 in the formula. Yes, if there's something we have to ask him, we'll ask him to give a copy, otherwise, word.
Registered office of the responding company in Mumbai, the jurisdiction of this court to appoint an arbitrator of the under section 7 of the Act is not yet clear. Even if a part of the contract action in the course of execution of contract has occurred within the state of Karnataka, this court can exercise its jurisdiction under section 11 of the Act.
Yes.
There is admittedly an arbitration clause between the parties. An arbitrable dispute also exists. So, I know this very clear man. There is no mention of the state of arbitration. Then the court has to rely on the cause of action. The cause of action in this case arises in Bangalore. Because the economic conflict is in Bangalore and the respondent works in Bangalore.
Your allegation is she breached it in Noida. The breach took place in Noida. That is why we asked you, since you are supposed to be having an office in Gurgaon. Either we appoint in Noida or Gurgaon. Mr. Suri said Gurgaon is fine. That's what your colleague was to get back on. So if you're
And
not
if it
within
is,
Noida, then it will be Noida now. So
if it is Delhi, it is also okay.
he fairly said Delhi or Noida is fine. Your client doesn't want to do about it. Petitioner is before this court, seeking for the following relief. The petitioner had appointed the respondent as an architect while appointment letter dated 4th April 2016. The same is governed by an arbitration clause in terms of clause 12 thereof, which is reproduced hereunder for easy reference. 12, 12.1, 12.2, 12.3. A non-solicitation agreement also came to be entered into on 28th June 2019. Thereafter, on the ground that the respondent had caused breach of the said agreements, the notice came to be issued on 14/1. A cease and desist notice came to be issued on 14/1/2021, which is replied to by the respondent stating that there is no violation of the agreement which has been committed. View thereof, the petitioner, while this letter dated 29/11/2021, invoked the arbitration clause and nominated its arbitrator. This is again replied to by the respondent, contending that the respondent is residing in Noida and as such is not agreeable for arbitration by the nominee arbitrator appointed by the petitioner in Bangalore, but is agreeable for arbitration at the Delhi International Arbitration Center if the petitioner is so willing. The petitioner, not being willing, has approached this court seeking for an appointment of an arbitrator under the aegis of the arbitration center attached to this court. Shri, what's your name? Shri so-and-so. The counsel submits that the petitioner had appointed the respondent as its employee in Bangalore, though the arbitration clause does not either mention the seat or the venue of arbitration. Since the appointment of the respondent was made for a job to be performed in Bangalore, an arbitrator can be appointed in Bangalore. In this regard, he relies upon the decision of this court in CMP number 84 of 2016, dated 16/3/2018. More particularly, para 7 thereof, which is reproduced here in the for easy reference. He also relies upon the decision of this court in CMP 68 of 2013, dated 22nd July 2014. More particularly, para 15 thereof, which is reproduced here under for easy reference. On the basis of the above, he submits that the petition be allowed and an arbitrator be appointed in Bangalore. Shri Umesh Suri, when a counsel appearing for the respondent, would submit that the agreement which is been referred to by the petitioner indicates the address of the respondent to be in Gautam Buddha Nagar, Uttar Noida, Uttar Pradesh. that the appointment letter mentions also. And a non-solicitation agreement refers the address of the respondent to be Ghaziabad, Uttar Pradesh. Even the notice which came to be issued on 14/1/2021 was addressed to the address of the respondent at Ghaziabad. Please and desist notice. The notice invoking arbitration clause was also issued to the respondent at the Ghaziabad address. He therefore submits that, apart therefrom, he submits that even the allegation made in the cease and desist notice, as also the invocation of arbitration notice, indicates that the allegation is that the respondent along with her husband has incorporated a company in Uttar Pradesh, having a registered office at Ghaziabad, and that they have breached the agreement in Uttar Pradesh. In view thereof, we submit that the arbitration would have to be held where the respondent is residing and not where the petitioner is registered, since the allegation is made that the respondent has breached the agreement in the place where she was residing. Heard so and so, produced papers. There is merit and substance in the submission made by Shri Umesh Suri, the advocate appearing for the respondent, inasmuch as the appointment letter is issued to the respondent at Noida. The notice has been issued to the respondent at Ghaziabad, and the allegation made is that the respondent has breached the employment agreement in Ghaziabad by soliciting the clients of the petitioner. The agreement being silent on both the seat and venue, and it is being stated that the party shall determine the place of arbitration. Since the petitioner and respondent have not arrived at and or determined the place of arbitration, it would be for this court to determine the place of arbitration. Correct. Having appreciated the correspondence between the parties, and it being found that the allegations are as regards a breach which is being committed in Ghaziabad, I am of the considered opinion that it is Ghaziabad which would have the jurisdiction to arbitrate the disputes, since not only is the breach committed there, but the respondent is also residing there by applying the principles of Section 20 of the Code of Civil Procedure. Hence, I appoint any names.
So I will be.
We'll call for from the Delhi High Court and we'll appoint
somebody.
Also, a former district judge of the Uttar Pradesh District Judiciary was appointed as an arbitrator to arbitrate the dispute between the parties in Ghaziabad.
Sir, there is a Bilesh Mathur. My suggestion.
No, we'll find out from the list. We won't go by any recommendation.
Yes,
we'll
right.
Get the list from Uttar Pradesh and appoint.
Okay. Sir, I will prefer sir, if it is in Delhi. So my learned friend has gone.
We can't now go by your preference.
Okay.
So both of you agree for Delhi, yes. Otherwise, we have to go by where it is.
Okay.
If both of you are agreeable, we'll have it.
Let Mr. Consul, it is agreeable to you in Delhi because you are having office in Gurgaon. So it will be convenient in Delhi. Even I am also in.
All of you go to Ghaziabad.
Ghaziabad. So he's not answering. So it is up to you, your lordship, wherever.
You appointed Ghaziabad.
Okay. Delhi, we have a better infrastructure for arbitration. Therefore,
don't leave. You consent and will record that consent. Appointed at this stage, the counsel for the petitioner submits that since the petitioner has an office in Gurgaon, an arbitrator could be appointed in Delhi and the arbitration could be conducted under the aegis of the arbitration center attached to the High Court of Delhi.
Highly obliged.
In view thereof, I pass the following. She so and so, the district judge, former district judge of the district judiciary of the state of Delhi, is appointed as sole arbitrator to arbitrate the dispute between the parties. The director, Delhi Arbitration Center, is directed to do the needful. All contentions are left open. Yes.
Highly obliged.
Highly obliged.
Appearing for petitioner, my lord. My lord, the respondent has noticed. The notice has been served on the respondent, my lord, and they have remained. They've kept themselves absent before this honorable court, my lord. This petition.
Yes.
This petition arises out of the arbitration clause mentioned in the service bond, produced at page number 22, my lord, as Annexure B. Clause 4 of the bond.
Yes.
Clause 4 of the bond is the arbitration, contains the arbitration agreement, my lord. So basically, this is an employment bond that was undertaken, that was executed between the petitioner and the respondent, and as per which the respondent undertook to remain in the employ of the petitioner company for a period of 3 years. However, my lord, the respondent abruptly ended exited the employ of the.
Yes, Mr. Counsel, will allow it. The petitioner is before this court, seeking for the following release. The petitioner issued an appointment letter till 7 September 2020, appointing the respondent to its employment. Thereafter, an agreement came to be entered into between the petitioner and respondent, which is governed by an arbitration clause in terms of clause 4 thereof, which is reproduced hereunder for easy reference, page 22. There being certain disputes between the parties, the petitioner removed the arbitration, issued a notice, invoking the arbitration clause on 10/11/2021, which was received by the respondent. However, which was refused to be received by the respondent, and as that was returned to the sender. Hence, one more notice came to be issued on 3/12/2021, which was again refused by the respondent. It is in that background that the petitioner is before this court. The notice has been ordered on the respondent. Service in favor of the respondent has been held sufficient, while order dated 2/9/2022. None has entered appearance for the respondent. Having perused the appointment letter under the agreement, it is clear that the disputes between the parties are required to be resolved by an arbitrator through arbitration. The petitioner has invoked the arbitration clause which notice has been refused to be received. Hence, I pass the following order. The Ram Rao Kulkarni, a former judge of this, former district judge of the Karnataka district judiciary, is appointed as sole arbitrator to arbitrate the dispute between the parties under the aegis of the arbitration center attached to this court. Director so and so. All conditions are left open.
Grateful.
18.
Hearing the agreement,
Agila settlement. The petitioner is before this court seeking for the following release. The petitioner and the respondent entered into. The petitioner and the respondent are partners who are parties to the deed of reconstitution of partnership dated 4th February 2021, which is governed by an arbitration clause in terms of clause 15. It is hereunder reproduced for easy reference on page 19. There being certain disputes between the parties which have resulted in filing of several proceedings. The petitioner had voided its notice dated 14/12/2021, invoked the arbitration clause and nominated his arbitrator and called upon the respondent to nominate his arbitrator. The respondent was reply dated 6/1/2022. Denied the said appointment, and it is in that background that the petitioner is before this court. Upon service of notice, respondent number 1 go ನೀವು ಹಾಕಿ ಹಾಕ್ತೀರಾ? Respondent number no first so and so submit that you would appear for respondent number 1. ಪಕ್ಕದ ಮಾಡ್ತಿದ್ದೀರಾ? File Vakaratnama for respondent number 1. Registry for printer's name of that appearing for respondent number 1. Upon service of notice, all the respondents have been represented. Today, none appears for respondent number 2 and 3. However, counsel for respondent number 1 and the petitioner submit that the sole arbitrator could be appointed. But without their consent, how do we appoint a sole arbitrator?
They have denied the appointment of arbitrator itself.
We will get into problem later under 34. Without their consent, we cannot reduce it. But without, we require a positive consent. Arbitration, we cannot make the agreement for you. You get them, and if they consent, then we'll appoint sole arbitrator. Otherwise, we'll have to appoint one arbitrator for all respondents. It will be 3 arbitrators.
Arbitration class also in case of among the partners, the same shall be referred to the arbitration for 4 arbitrators. Each party being able to nominate 1 arbitrator, arbitration of the majority shall be binding on all parties. Only the nominated and arbitrator, not the respondents are.
No, we will appoint 3 arbitrators on their behalf. They will in turn appoint the presiding first arbitrator. Know what the cost is going to be? We'll have 5 arbitrators. Constitutional bench. Get them to agree and get a sole arbitrator. We will have 5 arbitrators. That will be the first time. After arguing for some time, when counsel for the petitioner and respondent number 1 sued for and are granted a week's time based on 23/9. Yes, Mr. Desai.
The previous date of the court had raised the point with regard to the integrity of the petition itself, based on
Not this court, Mr. Desai.
the respondent had raised with regard to the integrity of the petition based on the 20% clause. Thus, I would like to make the following submission. Thus, first of all, the respondent has legally withheld the amount that is the performance bank guarantee and the security deposit. The second point here is that plus. As per the prerequisite for installation of an arbitration claim, I have raised the notice under
Mr. Counsel, you have done all of it. The only question that we asked you is, what is your claim going to?
Yes, I'll come to that point.
You first come to that, then we'll go to that. First, scale.
Sure. On 25 times, we have raised the notice. And as per clause.
You have to answer only two questions. Adella beda. What is your claim going to be, and are you going to restrict it to 20% of the value of the contract?
That's my humble submission is that the claim in its entirety should be allowed. Not just
Okay,
the
allowed, granted.
That's
Award passed. Great.
That's the reason why I'm seeking for this.
Please tell us the amount that you propose to claim, and is it within 20%? That's all.
Process that filing of the suit, no, I got your message. How long will it
Then
take?
you
to
can't
recover?
appoint an arbitrator. You have signed this with your eyes open. File a suit. File a suit. File a suit.
In the middle, this person is willing to settle.
Within 120 days, because the
Whatever it may be, if cost says 20%.
Indeed, but there is also another mandate. 100% of guarantee.
That's it. Permission to there's no much I highlight. Let's if I may refer to clause 63 and 64, that's right. General conditions of contract. Let's clearly states that once I raise a claim for notice of dispute, within 120 days, the railway board, that is the respondent, have to decide whether an arbitration is meaningful or not.
Yes.
But what has happened is that they have not done that.
Yes.
I have raised a notice of dispute on 25th of September 2020, but I received a response only on 17th September 2021, after a period of 1 year. So and that is the response that I have received from them is as in page number 52 annexure 3. They do not say that the dispute is not arbitrable. Rather, they say that the person, chief engineer, divisional railway manager shall be notified for appointment for conciliation, which means that they themselves are admitting that it is a matter to be arbitrated.
Conciliated is different from arbitrary.
That's the contractor before demand for appointment of arbitration. That's it is the point where I am seeking for appointment of arbitration. That's based on the default of.
Where is the reply? So the reply, page number?
That's page number 52 at annexure 15.
Should be reconciled and shall be referred to the contractor, the chief engineer, division manager. That's all.
But after a gap of 1 year, they have sent me this reply.
What were you doing for 1 year? What were you doing for 1 year?
Plus, I've been sending representation. I sent
Mr. Counsel, we can only enforce what is there in the clause. If you have agreed that you are going to restrict it to 20% of the contract value, there is an agreement that anything above will be outside the purview of arbitration. That's all.
Plus, there is also this particular clause under section under clause 63 itself. If I may be permitted to read the clause 63. It says that all disputes of any kind whatsoever arise out of foreign condition to the contract, whether during the progress of the work or after its completion, and whether before or after the termination of the contract, shall be referred by the contractor to the general manager and the GM shall within 120 days after receipt of the contractor's representation make the notified decision in all matters referred to by the contractor in the kingdom. So they have not taken a decision within a period of 120 days as they were dealing of as per the clause 63.
So does it override the 20%?
Dispute itself becomes arbitrary
Because they did not agree. Sorry, Mr. Khan. Make this connect. Petitioner is before this court seeking for the following reasons.
That's another clause that I would also like to subsequent clause, that is clause 64 minutes.
All that subsequent GCC, you have entered into a separate agreement, which you suppressed actually when you filed the petition. They produced it. Then you admitted it.
I produced it along with my petition.
Did you produce the agreements where this clause 28 is?
Plus, I did not produce it at that point.
There is the agreement dated 15/3/2017.
Well, I am relying on the letter of acceptance that was.
You cannot rely on whatever you want. Everything has to be faced. The petitioner is before this court seeking for the following release. The petitioner, the respondent number one having quoted a tender, the petitioner having participated and being declared a successful tenderer. A letter of acceptance was issued by respondent on 7/2/2021 for the tendered cost of rupees 5,17,21,281, which is accepted by the petitioner. Thereafter, an agreement came to be entered into, which made the general condition contract applicable. The agreement came to be entered into on 15/3/2017. The petitioner, by relying on the general condition of contracts, more particularly clause 63 thereof, submits that the dispute being required to be arbitrated, a demand was made, and the demand not being accepted within the time frame prescribed under section 60, under clause 64, an arbitrator is required to be appointed. Per contrast, S.B. Desai, Lord Counsel appearing for response, submits that it is not the general condition of contract which are applicable to the present matter, inasmuch as there is a separate contract agreement dated 15/3/2017, which has been entered into between the parties, and in terms thereof, it is clause 28, and it is clause 28 of the said agreement, which deals with arbitration, which would be applicable. And relying upon the same, we submit that the provisions of clause 63 and 64 of the GCC will be applicable only if the value is less than or equal to 20% of the original value, bracket excluding the cost of materials supplied free by railway, bracket close. Hence, it submits that the claim now raised being in excess of 20% of rupees 5,17,21,281, the same is not arbitrable. When the said issue was raised on the last occasion, the counsel for the petitioner sought for time to obtain instruction and make a submission as to what is the quantum of claim proposed to be made by the petitioner, and if the petitioner was restraining his claim to less than or equal to 20%, as contained under clause 28.
Really?
We can't refer to please see 28. It says the provision of 63 and 64 will apply if it is less than 20. So don't go back to 63 and 64 because this you have signed.
But the clause is overarching. This particular clause not for application will go beyond that clause 28 as referred to by the respondent.
Yes. It can't. There is a subsequent agreement, then the GCC. This is the general conditions for everybody. There is a specific agreement between them. That's what we have been saying. So today, we submit that the actual claim of the petitioner is more than 20%, and that we would not be restricting, that the petitioner would not be restricting the claim to less than or equal to 20% to contract value. Having today, the learned counsel for the petitioner will submit that it is the provision of clause 63 and 64 of the GCC which would apply, and clause 28 cannot override or have an overarching effect on clause 63 and 64, they being the general condition of contract. It therefore submits that irrespective of the petitioner claim being less than or equal to 20% of the contract value, more than the contract value, 20%, more than 20% of the contract value, the matter is required to be referred to arbitration. Third peruse purpose. Clause 28 is reproduced here under for easy reference. Statement of objections. The perusal of the above provision will indicate that the said clause, which is part of the separate agreement entered into between the petitioner and the respondent on 2017 restricts the applicability of clause 63 and 64 of the GCC to disputes of value less than or equal to 20%. Though clause 63 and 64 do not by themselves impose any restriction on the value of the claim, the petitioner has entered into an agreement with the respondent, agreeing to restrict the applicability of the arbitration clause to less than or equal to 20%. Today, after having entered into the agreement and having performed the portion of the agreement and received monies there and there, it would not be for the petitioner to claim that the said restriction under clause 28 cannot override clause 63 and 64. An arbitration agreement arises out of contract between the parties in terms of section 7 of the Arbitration Conciliation Act 1996. It is for the parties to determine the manner and mode of arbitration as they deem fit as per the agreement that they arrive at. Having arrived at an agreement between the that the petitioner cannot raise a claim of can only raise a claim of less than or equal to 20% by way of arbitration under clause 63 and 64. I have a considered opinion that now the petitioner cannot seek for arbitration of a claim more than 20%. It is not that the petitioner is remediless. The petitioner would always have the remedy of filing a civil suit, seeking for recovery of the amounts that the petitioner claims to be due. Since the respondent has contended that the arbitration clause is not applicable to a claim more than 20%, needless to say, the respondent cannot raise a defense of the existence of the arbitration clause in any suit filed by the petitioner. For all the aforesaid reasons, no grounds have been made of the petition stands dismissed. Needless to say, liberty is reserved to the petitioner to avail such other and further remedies as are available to the petitioner under law.
20%, but the claim amount for 20%.
We are not asking you to restrict. Please go ahead and get your claim. Only last time you said you'll find out. If you have a 2 crore claim, why should you restrict? Get it from them. Next time, don't sign this agreement. Now you know. The petitioner and the respondent have the counsel for the petitioner and respondent submit that the dispute between the parties have been amicably resolved, and the respondent shall make payment of the sum of rupees 12,00,000,000 towards the settlement, an amount of rupees 6,00,000,000 having been paid while demand draft bearing 177873 drawn on Indian Overseas Bank, Foxtown branch, dated 12/9/2022, and the balance amount of rupees 6 lakhs being paid while demand draft bearing number 177874 to a sum of rupees 6 lakhs. In view of the said settlement and receipt of the monies, both the counsel for the petitioner submit that he does not wish to prosecute the above petition. Accepting the said compromise and the submission, the petition is dismissed as settled. Yes.
But the parties had entered into a sale agreement at annexure B on 3/20/2018. Not at page 27, you got the arbitration clause. This was a sale agreement in respect of the original agreement.
2017.
Lord, 3/12/2018 agreement annexure B, Lord. That was the first agreement between the parties.
Yes.
Respect of sale of a commercial property. At page 27, Lord, the arbitration clause is clause number 17. Thereafter, the respondent defaulted. He did not sell the property as a gift. Then an arbitration application was filed. During the pendency of the case, they came around for a settlement. Settlement deed was entered, which is at annexure A. Page number 30. This was during the course of arbitration. In this, they said instead of one commercial property, we will do
Page number 31.
31.
1.
Annexure A was the deed of sale. So this also has arbitration clause, clause 9816. And this says, in the event of breach of the terms of this claim, the settlement made.
According with the agreement and the agreement defined as well.
Agreement is defined.
That's what?
As the other agreement at page number 40.
3/12/2018. Yes.
3/12/2018, the other agreement that I showed. Then this also contains an arbitration clause in which they said, instead of the schedule A property here, we will bring two apartments and schedule B. This has also not been done. Therefore, I have issued an arbitration notice at annexure B, page 34.
Petitioner is before this court seeking for the following release. The petitioner and the respondent were entered into an agreement of sale to the 30/11/2018, which is drawn by an arbitration clause in terms of clause 17 thereof, which is reproduced here under page 27. There being certain dispute which had been entered, which had arrived, the parties negotiated a settlement and arrived at a settlement on 2/2/2021. The said settlement is also governed by an arbitration clause in terms of clause 9 thereof, page 16, which is reproduced here under page. The agreement referred to in clause 9 is defined in the said agreement to be the agreement of sale dated 3/12/2018. As such, it is the arbitration clause under clause 17 of the said agreement which would apply, and on that basis, the petitioner had issued a notice dated 24/11/2021 invoking the said clause and appointing its arbitrator. Though the said notice has been received by the respondent has not consented to the appointment of an arbitrator, and as said, the petitioner is before this court seeking for the opposite relief. The notice has been ordered to the respondent and served. None has entered appearance for the respondent. Having produced the agreement, it is clear that there is an arbitration clause which governs the dispute between the parties. The invocation being made by the petitioner being proper, and the considered opinion that an arbitrator would have to be appointed to arbitrate the disputes. What is the claim amount?
1.5 crore.
M.K. Shripati, a retired district judge of district judiciary, is appointed as sole arbitrator under the aegis of the arbitration center. All conditions are met. Yes. Mr. Vivekananda, any objection? Serious objection. Page? Page? 81.
There are 7 institutions listed where
81 will be there. I mean petition. 81 is special condition of contract, compliance with labor regulation. 82. 82. We have not opposed any of them.
But afterwards, they initiated promised that they would appoint, they would allow monitoring to work from.
We are not concerned with that. We followed 4.1. Yeah. So you choose anyone, you are left with the option. They cannot find any fault. You choose 1 or 5, get it appointed and go ahead. Who doesn't have the appointment? Who doesn't have the appointment? How do you say it is ad hoc?
The arbitration should be done in accordance with the arbitration will be set
That's all.
in 4.1, 4.1B. In case of dispute or difference arising between enter and the contract relating to the investment arising out of a certificate it shall be settled according to the arbitration procedure and 1886. The dispute shall be referred to arbitration. For arbitrators should be appointed to the agreement between the parties, paying respectively and the appointed.
This clause is neither here nor there. The mixture. If they go to ICJR, you will have to go before the ICJR and comply with those rules. You cannot have the arbitration before the principal secretary, his office, and or the cost to be determined like that. The cost will be determined by ICJR. If you are going to make that submission, we will record it and ask them to go there. No, we are not restricting. You will follow the ICJR rules or rules of any of these 7. You will follow those rules. You choose any of them, they are willing to follow the rules of any of them. They can't be only appointing, they won't do it as appointing authority. They are not like the High Court. They will keep control over the administrative expenses. If the consent, that is good, but for being government organization, they can't even ask it. They can't ask. If you want that and then it doesn't happen, then you can't come back here. No, all arbitrations are held here. ICDR arbitration we have done, council, ICA arbitrations are done, road congress we have done, building congress we have done, bridge Gottila, public health Gottila, whatever is Gottila. Others, all arbitrations happen in Bangalore. The only thing you will have to do is you have to pay them administrative expenses without any administrative service. They won't give you any service. If you go to Delhi, they'll give you the service. Here, they won't give you the service. Petitioner is before the court. This court speaking for the following reason. The petitioner, the respondent having invited a tender, the petitioner was the successful tender for construction of grade separator of Bengaluru and Vara Junction in Mysore city. Thereafter, the petitioner and the respondent entered into an agreement. The general condition of contracts, clause 24.3 of the general condition of contract provides for arbitration to be conducted in terms of the procedure stated in the special condition of contract. Clause 4 of the special condition of contract deals with appointment of an arbitrator. The said clause 4 is reproduced hereunder for easy reference. The petitioner invoked the arbitration clause. Why this letter dated? 29/7/2021. 17, so 172 is 29. Where is the first one? 17 December 167. 17 December 2020. Page 17th April 2018. Calling upon the respondents to make payment of certain amounts of monies, failing which it was informed that clause 24 of the GCC would be invoked. When the payments were not made, a second notice came to be issued on 17 December 2020. Again, stating that clause 24 of the GCC would be invoked if the payments were not made. Finally, a notice came to be issued on 29/7/2021, nominating an arbitrator, but stating that the arbitration would be held in the arbitration center attached to this court. When no response was received to any of the notices, the petitioner has approached this court. Upon service of notice, the respondent has entered appearance. The counsel for the petitioner submits that in terms of clause 24 of the GCC, clause 4.1 of the special condition of contract has been made applicable, and therefore, since the arbitration is to be held in the office of the principal secretary, it is an ad hoc arbitration, and as such, the authorities named in the schedule to clause 4.1 cannot only act as an appointing authority, and it is for that reason that the petitioner has invoked the arbitration clause and appointed a nominee for ad hoc arbitration, with the arbitration to be held in the office of the principal secretary. Okay, Vivekananda TP, the counsel for the respondent would however submit that the agreement which has been arrived at is for the authorities mentioned in the schedule to clause 4.1 to appoint an arbitrator, and that the arbitration proceeding will be held under the aegis of the said institutions mentioned in the schedule. Otherwise, we will raise that objection. He is consented to this. You are reading the clause, we are going by a submission. He submits that if the petitioner were to approach any of the authorities under the mentioned in the said schedule, the respondent is agreeable for arbitration as per the rules of any of such authorities mentioned therein. In view thereof, that is a different. On merits, merits are different. Merits are different. In view thereof, the clause 4.1 providing for specified authorities to appoint an arbitrator. I have the considered opinion that the petitioner cannot either seek for appointment of an arbitrator by himself in ad hoc manner or approach this court. It is for the petitioner to approach the authorities who have been designated as the appointing authorities under the said clause 4.1, reserving liberty to the petitioner to approach the said authorities for doing needful in terms of the rules and regulations applicable to such authorities. The petition is dismissed. Same matter. Next one also. Date. For construction of grade separator at JSS Nanjanpur Road Junction in Mysore City. Date of the agreement. Same. Same, last time. Issue notice to respondent returnable by 4/11. Yes, madam. Yes, madam. Where is the arbitration clause? Arbitration agreement, where is it? Where have we invoked the arbitration clause? Where is your arbitration notice? You are not appointed arbitrator, madam. Ask your senior to come next time. At the request of the counsel for the petitioner, read this on 23/9. If there is a notice which you are issued naming the arbitrator, produce it. Learned counsel for the petitioner seeks for and is granted a week's time to produce the notice invoking the arbitration clause by nominating an arbitrator. We list on 23/9. All three are the same. 26 is also same. Same. Yes. Mr. Chetan Kumar. Though counsel for the petitioner is present and ready to address argument, none appears to respond 1 to 3. If none were to appear for respond number 1 to 3 on the next date of hearing, the matter will be taken up for consideration in the based on 23/9. There are so many counsels on this side. That was good. Conciliation by whom? Arbitration center doesn't have. Mediation center has. Who is there in the panel? We don't have the panel list. So nobody has been appointed. It is there in the rules, but nobody has been appointed. We can refer it to mediation. The same thing. Both are not binding. The counsel submit that if the matter is referred to mediation. Then go for arbitration and get it. Conciliation is nobody is there. I don't think even in mediation. Find out and make a submission next week. If there is a conciliator who has been appointed in Learned counsel submit that the matter could be referred to conciliation. They seek for and are granted a week's time to make the submission on who the conciliator could be under what institution. We list on 23/9.
Next again, item number 16 is the arbitration clause, page 16. We issue a notice there is a dispute regarding the payment of the amount. Notice was served and answered to that. Page 16.
Where is your notice?
What is next annexure B? Apartment annexure C.
Really, you are not named the arbitrator, Mr. Shiva.
No, you stated so much. Therefore, I hereby call upon you to refer me about the dispute to sole arbitrator as per section 16 I have statement.
Who is to
Responding to that. Last paragraph.
by the company
Yes, sir.
issue notice to respondent returnable by 4/11/2022. Emergency. Who is for the respondent? Give it in section 11. And you'll get an interim order and run away. None appears for the respondent, none will appear to the respondent on next date of hearing, matter will be taken up for consideration thereafter. Previous term 23/9. Mr. Naraji Deepak. Same order. Yes. So ready?
Yes.
I think sole arbiters. Because you are a government organization. The petitioner is before the court seeking for the following relief. The petitioner being the respondent quoted a tender, the petitioner being a successful bidder for consultancy services for construction and supervision of contract administration. Was awarded the contract. The said contract is governed by the GCC. Where is the arbitration clause?
Page 54, page 48, page 48.
Which is governed by an arbitration clause in terms of clause 8.1, page 48, which is reproduced here under for easy reference.
And page 54, the C is language.
Where is your notice? Where is your notice?
Not, I think, page 190, 24th of October. 24th October, 190. Page number 190.
Raising certain dispute, the petitioner has invoked the arbitration clause while his notice dated 14th October 2021. And nominated as arbitrator and requested for the appointment for the arbitration.
He has applied and rejected on taking the 200, rejection the appointment of the same 19 member.
The same came to be replied to by the respondent. The details reply stating that the allegations made on the notice are not tenable and are denied, and further that there are no amounts which are due and liable to be paid. The respondent also denied the nomination of the nominee of the petitioner to be the sole arbitrator. It is in that background that the petitioner is before this court. For notice being served, respondent is entered appearance and filed an affidavit of the project director of the project implementation unit of the Karnataka State Highways Improvement Project. In the said affidavit, it is stated that the respondent has no objection for that the disputes to be resolved amicably by a sole arbitrator to be the arbitration to be conducted in the arbitration center attached to this court. The counsel for the petitioner also submits that a sole arbitrator could be appointed and the arbitration could be conducted in the arbitration center attached to this court.
Okay.
What is the claim amount?
About 1 crore plus 1 crore plus.
1 crore only.
Yes.
When counsel for I the petition is allowed.
1.25 lakhs for the interest.
G.N. Srikantaya, the former judge, the district judge of the district judiciary of the state of Karnataka, is appointed as sole arbitrator to arbitrate the disputes under the aegis of the arbitration center attached to this court, director, all contention are left open. Who's going to take? Railways, 63, 64. Where's your notice?
They had appointed in Karnataka. But that was in violation of section 12(5). Hence, and
issue notice to railways. SV Desai railways. You also appear? Not in the time. So SV Desai, standing counsel is guided to accept notice for respond 1 to 3, counsel to the petition is not complete. Objection is returning by 14 previous and 21. October.
Here on behalf of the respondent.
Any objection, Mr. Joshi?
Not only one, the procedure is not followed. The procedure in the agreement requires that the parties must first go for conciliation as per the conciliation rules of the respondent corporation. That is the only objection that has been submitted.
So you want us to refer to conciliation now?
The conciliation will be as per the clause set out at page 79, which is the corporation's conciliation rules. This is a matter that will get settled by Lord. I'm informed about that by the party. Let them just approach us through the right process. It will get worked out. Page 79, clause 15.6.
It is mutually owned.
What has happened is from last 1 year, I have been going from one forum to another forum on their request. Initially, I first approached them.
Why are you sending them from one forum to the other forum, Mr. Joshi?
The venue is Delhi.
Meeting takes place. Even according to them, meeting has taken place, and they say because of these rules, we cannot do it. We must file a petition before being there. We filed a petition. There was no forum interest. They issue a demand notice. I filed the petition. They come into the petition. They say your alternative are remedy, file arbitration. We agree to them. We withdraw the PMTR petition. They appear in their work. We withdraw the restriction. In fact, yesterday the disclosure was taking place. My only first why I'm making this.
Why should we give credence to your 15.6A, Mr. Joshi? You have been advising them to go all over the place.
Not at all. Not at all. Why not? They have in fact been forum shopping. They have filed to writ petition. I have supplied gas. They owe me money. I have done
shopping.
I have supplied gas. They owe me money. I have not taken a single step against them. They have filed 2 writ petitions. Then they approach the Petroleum Regulation Board. They get no reliefs anywhere.
Once Mr. Joshi's submission is there. Then you continue speaking. The petitioner is before the court speaking for the following week. No interim relief, we can't give you that.
Well, he is not completely audible, but I heard interim relief. His remedy lies under section 9.
No. What he's saying is that yesterday is an order of interim order has been passed in his favor, final disposal, which is in force for a period of 4 weeks, or the disposal of the CMP, whichever is earlier.
Correct. So today it will come to an end. It will come to an end. Yes, he is at liberty to move section 9, and my lord, we have not taken any steps against him. We have not taken any steps against him.
Adjourn this by 4 weeks. we'll ask him to go before 50 authority under 15.6A and come back. So that will also keep pressure on your authorities to do it within 4 weeks.
And his conduct will be borne out if he approaches us under 15.6. I spoke to him yesterday also. I told him just submit an application under 15.6, it will all get worked out.
Yes. Don't complicate it further. Dhananjay Joshi, when a senior counsel, submit that the petitioner has not approached the conciliation authority in terms of clause 15.6 bracket A of the GSA for supply of RLNG. The council faced, the petitioner faced with the above situation, submit that you will approach the said authority within 2 working days. The conciliation authority to consider the same and try and resolve the matter.
We don't know what the rules provide for, they'll follow the rules.
By following the applicable rules. Released on 14/10.
Right.
Same order 36?
Yes, madam.
Same order 36, same order. In 37, you are appealing, Mr. Now. This will require some time, so we'll have it next week. 37 released on 23 now.
Okay.
38 to 41, connect to 37 and release on 25.
54 to 64.
54 to 62 also.
Number 42. Landowner entered into an agreement with the builder and with the profit sharing ratio of 40/60. They have given part payment for the balance they are not giving. And
Where is the arbitration clause?
yes, the arbitration clause is clause 25.3 at page 46. Now also issued arbitration notice, which is an annexure at page 74. We also explored conciliation, madam.
Where is that letter for conciliation?
The conciliation via email now, there is a record annexure E. It says mediation has failed. Annexure E, page 70. In fact, for more than 7 to 8 months, it was explored at various levels. And ultimately failed.
Yes.
Because the annexure F, when we sent a notice, we suggested a chartered accountant's name as a arbitrator, the arbitration and conciliation center. And then suddenly they changed their stand, take this amount, some random amount of 1,71 lakhs. What if there is no?
Notice the response recognized by 411.
It's another time. 42 and 46.
46 things.
Serial number 45, my
43. Yes. Any objections? There is no objection. The petitioner is before this court seeking for the following relief. The petitioner. The purchase order came to be issued to the petitioner on 3/10/19. When was it issued? 5/10/2018. And on subsequent dates. The said purchase order is drawn by the arbitration clause contained in the GCC page. General condition of contract, page clause 45, page 81, which is reproduced here under 2 years. The petitioner there being certain dispute, the petitioner had invoked the arbitration clause and appointed as arbitrator. The respondent, not being agreeable to the said nomination, the petitioner has been constrained to approach this court. Upon service of notice, the respondent has entered appearance. The counsel for the respondent submit that an arbitrate, that there being no dispute as regards the arbitrate clause. The suitable arbitrator could be appointed by this court. What is the claim amount? Sri D.S. Muthoor. Sri D.S. Muthoor, a retired district judge, so and so is appointed direct arbitration center. So and so. The so and so accepts notice for the respondent. 44. None appears for the petitioner. Read this from 23:9. He is not here also. Pick up the phone and speak to. Pick up the phone and speak to. Yes, madam.
Krishna, my lord. My lord, this is a dispute arising out of a partnership deed, my lord. The partnership deed is provided at Annexure D. The partnership clause is at clause 19.
19. Page?
Page 68, my lord. 67. Clause 19.
Yes, notice.
Notice.
Where's the notice?
The legal notice is at B, Annexure B, my lord.
Page?
Page 55.
Give us the annexure number, but page number is more important.
Yes.
You not nominate an arbitrator, madam.
We have not named an arbitrator, my lord, but
If you don't name it, then it's not a proper notice.
we have mentioned that at the very end, I call upon to agree to appoint an
That
arbitrator.
cannot be. That cannot be. You have to nominate. So there's a
Point
defective
17.
notice. You issue a notice and get back. A referral of the notice dated 8/3/2022 indicates that no arbitrator has been named. Therefore, the said notice being defective cannot be considered, reserving liberty to the petitioner to issue a fresh notice by nominating an arbitrator. And if necessary, to approach this court. The petition stands dismissed.
Your lordship.
47. Issue notice to the respondent returnable by 4/11. Okay. Yes. Arbitration clause. Page. Page? 404. ಇದೇ ವರ್ಡ್ ವಾಲ್ಯೂಮ್ ಇದೆ. ಇನ್ನು ಆರ್ಬಿಟ್ರೇಷನ್ ಮುಂದೆ ಎಷ್ಟಿರುತ್ತೆ? ಕನ್ಸಿಲಿಯೇಷನ್ ಇದಾಗಿದೆ. Where is the notice? Claim petition is last year. Where you ask for conciliation?
I have submitted my claim.
Where is conciliation?
25.1 says,
Hmm.
when he is submitted, and it is not decided for us, then 25.2 and 3 others. No particular procedure allowed in.
Issue notice to the respondent, where the standing counsel there. Sarita and Kulkarni is directed to accept notice for respondent counsel for the petition to office. Objections returning by 14th, released on 21st. Yes.
Page 28. Actually, last but one paragraph is the arbitration clause. Page 50.
Issue notice to respondent returned by 4/11. Any objection? Any objection for appointment of an serious objection? Counsel for response seeks for a week's time, released on 23/9. Page?
Page number 48. Arbitration clause is found at page number 46 and clause 7.2.
Mediation has happened.
Mediation is the attempted mediation, which is a non-starter. Emails were received from Justice Ravindran on the point of meeting at page number 112. We have initiated mediation via email, which is found at page number 121.
No reply.
My lord's reply was there, which is found at page number 180. I write on behalf of my client, Mr. So-and-so, our clients respectfully submit that they are not agreeable to attend mediation.
Issue notice to the respondent returnable by 4/11. Counsel for the petitioner is also permitted to serve the counsel who has replied to the arbitration notice. Counsel for response seeks for and is granted a week's accommodation, released on 23/9, 52/53. 63. Counsel for response submit that there are settlement talks going on. If a week's time is granted, they will report. 2 weeks' time is granted, they will report settlement. We list on 39. Yes, Mr. 64. 64. Railway, na? Sri S.V. Desai. M.N. Kumar, railway appear ಆಗ್ತದಾ? Sri M.N. Kumar. Copies to be furnished. Objection if any by 14, released on 21st. Page number?
Page number.
Notice. Notice, yeah.
Page number 39.
Where you nominated the arbitrator? Arbitrator yesterday ಹೇಳಿದ್ದೀರಾ?
how it is like, not seeing what is that, they have made the respondent that.
Our advice ಅಂದ್ರೆ ಅಲ್ಲೇ ತಗೊಳ್ಳಿ, ಇಲ್ಲಿ ಬರ್ಬೇಕು ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು? Reserve liberty, initiate, issue fresh notice and come. The period notice dated 19/4/2022 indicates that no arbitrator has been nominated, except for reference being made that the petitioner would approach this court if the payments due are not made. In view thereof, reserving liberty to the petitioner to issue a fresh notice, nominating an arbitrator, and if needs to arise to approach this court. The petitioner ನಾಳೆ ನಿಮ್ಗೆ 34 ಅಲ್ಲಿ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತಪ್ಪ, ಸೆಟಿಸ್ಫೈಡ್ ಆಗುತ್ತೆ. Yes, where's your notice? Issue notice to respond, you come at 411. None appears, released on 23/9. 68. Was 24.2. 36. Yes. There is a notice. Issue notice to respond by 411.
Your Lordship, 67, Your Lordship, appearing for the petition.
67.
Please, Your Lordship.
67. 67, you are also.
Your Lordship, agreement.
67 to 68. How the man mixed up?
67, Your Lordship.
67, since we are not there, we adjourned it to next week.
Your Lordship, I was on the online.
Now, no. Yes, madam.
On page number 133, however, arbitration clause is against section 12(5). By way of this honorable court's judgment, on page number 152.
152.
152.
Yes.
This is an order of and by both the CMP and article was appointed. And an award was passed. How the award is established by both the parties in award was satisfied. Now, my lord, we have to reinitiate the application procedure. And then notice the procedure, notice can be found on page number 2.
Issue notice to response to M.N. Kumar, accepts notice for response. Copy to reserve. Objection by 14, rejection 25.
Number 70 minute, page 15, class 21.
21.
Yes, page 15, class 21.
Yes.
Legal notice is at page 19.
Where have you nominated the arbitrator?
It does not provide, my class 21 does not provide, it only says we have to approach me. That's all.
Shall we refer to arbitrator? You have to nominate an arbitrator.
No, it does not, the class does not provide arbitration class.
Arbitration Act provides for it. So you should nominate under section 21, otherwise it is a defective notice. Please issue a notice and come back again.
Please.
The table of the notice dated 19/7/2022 indicates that no arbitrator has been named. The same being defective cannot be, the same is defective.
Can you keep it pending, my lord, and issue notice?
No. The liberty is issued, reserved to the petitioner to issue a fresh notice and if need be to approach the court.
Please.
Okay. Post before a bench of the judge will have a conflict.
My lords, in serial number 72, my lords, I appear for the
71, madam.
Please, I apologize.
Tonight, none appears, released on 23. 71, 72. 72, you are appearing, madam?
I appear for the petitioner in this matter, my lords.
Yes.
My lords, the dispute arises out of the arbitration construction agreement at page number 14, my lords, of my petition.
Where is the notice?
Notice is at page number 40, my lords.
Issue notice to respond written by 411.
Grateful.
Mr. Abdullah. Notice. Issue notice to respond written by 411. Page? You not named the arbitrator, madam. The Delhi High Court judgment says which if you don't nominate, it is defective. Then later it gets dismissed. First, new nominate ಮಾಡಬೇಕು. You ಮಾಡಲಿಲ್ಲ issue another notice and come back. You are not named. You have to name. The table of the notice dated 23/7/2022 indicates that the arbitrator is not been named. Hence, the notice is defective, reserving liberty to the petitioner to issue fresh notice by naming an arbitrator in compliance with the Act. Arbitration conciliation of the petition is dismissed. Yes.
At page number 20, Your Honor. Clause 27, and the notice is on page number 41. That's the notice, Your Honor. 46, we have the arbitration matter. Suggested or not.
If you notice, now you know what is done. If you notice the response is in the 411. Yes. 8:37. Where you name the if you notice the response is number 411. Same, huh? Same 411. 78, same 411. Where the consultation notice?
Consultation period, period. This is your the balance in 2019. After that, we've been following up and getting it on. So we sent a demand in November 2021. Following which it
It's only the period, not the notice. Where is your notice?
Page number 47. Page 48, para and two.
Issue notice to respond returnable by 4/11. This is a partnership deed. Partnership deed. Why you made the partnership firm a party? First respondent cannot be a party. You can't make a partnership firm. Your dispute is between partners. The counsel for the petitioner seeks permission to delete respondent number 1 from the area of parties. Is so permitted. Amendment to be carried out and fresh past title to be filed. Issue notice to respond within by 4/11. Connect to 37. No, different. Good.
That's very good additional. Page 26, we have action.
26.
Plot 10.
Notice.
Notice is my lord at page 39. Notice, page 39. Notice.
If you notice to respond within by 4/11.
Okay.
Page. Post before a bench of which DRJ is not a party. Not before me. 83. 23. Because your contention is this against 12.5. Issue notice to respond within about 4/11. Which matter in 23940? 23940, na? Only the 10,489. Last matter, yes.
Make one submission,
Yes,
if I
Mr.
am not interrupting.
Yes.
Today in the Harvard, the order to learn that may not be something that Sunday when I school. Just as a matter of information and reading to the
Yes. Yes. Really? What are you doing in 10,489?
In this matter, my lord, I am not present that where.
Today, application.
Only submission would be my lord. And the value is taken as on 1/1/2014.
What are you not pressing, Mr. Angel?
What B, C and D, my lord.
Why do you have to state all these things? It's irrelevant stating all these things when you're asking for deletion.
Land I can hesitate before the land I can.
Any objection to this? Sir, ಮಾಡಿ ಕೊಡಿ ಯಾಕೆ ಹಿಂಗ್ ಮಾಡ್ತೀರಿ? ಆವಲಿಂದ ಇಲ್ಲೇ ಕೂತಿದ್ದೀರಾ?
And this was, actually, I had a submission of the. Such a, this can be that. It made the same
Counsel for the petitioner in WP 10489 of 2015 has filed an application for amendment. Copy thereof is served on the counsel for respondent. And counsel for respondent seeks for and is granted 2 days time to go through the same and make a submission. Next. 23940. We are not passing any orders. Let them file their order. 23940.
That my lords, my rights are ready for my lords.
This is very unfair. Why we just accept Mr.
If this award is based on by whether it's a speed or not, then there will be a conflict of awards. That's the reason to file the hearing.
Then we will. When counsel for the petitioner submit that he wishes to address more arguments. If at this stage it is not permissible, then it is dealing and matter is referred to the roster bench. We'll give out everything, Mr. Gunja. This is not fair. After arguing for this much time, making the submission. We will release all these matters. We will release all these matters. We don't appreciate this. We will release all these from parties. Release. No, Mr. Ravi, this is not the way it is done. If you can't take the court for a ride like this between yourselves. All the release the matter from parties, post it before the concerned roster judge. How much patience can we have? Thrice? All of you have wasted this court's time, that's it. After having made such a submission, now coming back and making this submission, it's very unfair, Mr. Gunja. You can rely on any judgment before the roster bench, we have released it. Released from party. This is not the way to be done. It should not be done like this. All of you submitted the same thing. Now you are having a different thing. It cannot happen like this. Release. Better, Mr. Argue it again. Argue everything. Mr. Gunjal wants to argue everything, let him argue. He'll again go start with the same thing. I won't press, then again the same thing will happen. It will go on for another 20 years. Let it go on.
ನನಗೆ ಇದು ಕೊಡಲಿಲ್ಲ ನೋಡ್ತಾರೆ ಯಾರು ಗೊತ್ತಾ ಸಿಕ್ಕೋದು ಎತ್ಕೊಂಡು ಹೋಗ್ತಾರೆ ಇಲ್ಲಿ ಸಿಕ್ತೆ ಮೋಸ್ಟ್ಲಿ ಅಲ್ಲ ಸಿಕ್ಕೋದು ಇಲ್ಲ ನೀವು ಅಲ್ಲ ಹಾಕಿದ್ರಿ ಆ ಬಣ್ಣದಲ್ಲಿ ಇಲ್ಲಿ ಆಗಲ್ಲ ಏನ್ ಮಾಡಬೇಡಿ ಅಪ್ಪ ನನಗೆ ಅಲ್ಲ ಮೇಡಮ್ ನೋಡಿ ಮೂರು ಸರಿಯಾಗಿಲ್ಲ ಕೂತ್ರೆ ಅದನ್ನ ಕಾಲೇ ಇಲ್ಲ ಬಂದೆ
ಅದೇನು ನೀವು ಹುಡುಕೋ ಫೈಲ್ ನೀವು ಹುಡುಕ್ತಿರೋ ಅದೇನು ಫೈಲ್
ಸರ್ ಇದೆಲ್ಲ ಅವ್ರಿಗೆ
ಹೇಳ್ತೀರಪ್ಪ